Good morning, everybody. Welcome to the first day of hearing number 5 on the Wellington City Proposed District Plan. We are looking at various district-wide provisions that have IPI status in the plan. The hearing panel for this particular stream will comprise myself, Robert Schofield as the chair, Jane Black on my left, and on my right we have Commissioners Rari Faulkner and Lindsay Dash. I will point out that Mr Dash, while he's on the panel generally for this topic, he won't be deliberating on airport noise or centreport noise issues because of various conflicts. Commissioner Black here won't be deliberating on natural hazards, so she won't be here tomorrow, has the day off. And I will recuse myself from Transpower and Horakiwi Quarries, even though they're not attending the hearing themselves. So that's our sort of management of that particular issue. The first 2 days of the hearing will be devoted to attending to the council's reports and statements of evidence and the rebuttal to submitted evidence that they've seen to date, and answering any questions from the panel. We do have some very big, wide topics here and some very important planning principles in question. So we hope to have a fairly rigorous debate with council witnesses and officers on those topics. The usual thing, I presume everybody knows around the health and safety of this building's floor. Cell phones should be off or on silent, please. So the first topic for this hearing will be noise, and that will take us right through to lunchtime with a break in between. And I'll get Mr Ashby to present the speakers for the council this morning. Just before lunch, we are looking at having a half hour or so around Three Waters issues, provisions. And following lunch, we had earthworks and subdivision, and tomorrow the whole day is devoted to natural hazards. So that's a key thing. We haven't attended any site visits in particular for this topic, but we have that in mind, and we do have some capacity next week to do site visits. If any submitters or council officers want to point us to anything to look at, we're happy to do so. Other than that, we are open to all suggestions. So with that, no further ado, unless there's any other questions around procedures for the hearing. Okay, we'll hand over to Mr Ashby. Now, Mr Ashby, we do have a tabled statement, and I'm presuming you'll be talking to that first thing. Okay, thank you. Over to you.
Thank you, Commissioners. Good morning. I thought perhaps just a quick round of introductions to start with. At the far end of the table, Mr Malcolm Hunt, who's an acoustic expert, who you'll probably be familiar with. And in between myself and Mr Hunt is Mr Sean Simon. Mr Simon is also an employee of the same company that I work for. And he has particular expertise in rail noise and vibration. When you come to that. So, would you like me to, given that this introductory statement's just been tabled this morning, would you like me to read through that, Commissioners?
I think that would be helpful. Thank you.
This memorandum briefly introduces the noise chapter work and outlines key changes that the council has recommended in response to the evidence in chief of submitters. In reviewing and responding to the evidence in chief of submitters, I worked with noise experts Malcolm Hunt and Sean Simon. And Mr Hunt and Mr Simon are also here to answer questions of the panel. The experts had responsibility for different aspects of technical advice, as is explained in their evidence in chief. However, there were also strong elements of collaboration and peer review in the way we worked as a team. We also worked with the council's internal noise and compliance officers, seeking their advice and review at key stages in the earlier process of responding to submissions. At the same time, we also engaged with some key submitters, being Wellington Airport Company, Waka Kotahi, Kiwi Rail and Centreport. Our supplementary evidence in response to the evidence in chief of submitters includes some key changes which I outline below. As part of our evidence, we prepared a revised version of Appendix A of the Section 42A report. Appendix A sets out the noise chapter in full with marked up changes. It also sets out selected excerpts and marked changes from other parts of the PDP, such as the definitions section. Moving on to those key changes. In Appendix A, changes recommended in the original Section 42A report are marked in red. Further changes recommended in response to the evidence in chief of submitters are marked in blue. Key changes introduced in the blue version are outlined in the following paragraphs. In the original Section 42A report, we recommended a helicopter noise advisory overlay to be mapped in the vicinity of Wellington Regional Hospital at Newtown. This was accompanied by an explanatory note added to rule noise R4, but with no changes to the permitted activity status of helicopter activity at the hospital zone, as was our intention. Our current recommendation is to also add the advisory overlay as a definition to provide further clarity as to its purpose. And taking a similar approach, we have also recommended a railway vibration overlay and definition, as I discussed below. Vibration from railways is agreed by the Council and KiwiRail to be an issue. However, the Council disagrees with KiwiRail's proposed approach to setting a vibration standard, as noted in the evidence of Mr. Simon. As a compromise position, which is a suggestion made by KiwiRail, Appendix A introduces a definition of rail vibration advisory overlay. It would apply to land 60 metres either side of the railway corridors. Our recommendation is that the overlay remains in place until and if a workable rail vibration standard is developed. As I note above, to accompany and explain the overlay, we also recommend a definition. The noise chapter includes provisions related to what we have termed high and moderate noise areas. Because various zones comprise each of those areas, the noise chapter policies, rules and standards originally spelled out each of the zones in full. This contributed to a lack of clarity when reading those provisions. As suggested by Wellington Airport, we have therefore recommended adding definitions of the high and moderate noise areas so that the terms can be used as shorthand in policies, rules and standards. We've recommended that Rule 3, that's noise R3, should be substantially modified. The rule is a key part of the noise chapter as it seeks to manage the nature of development and activity status in the high and moderate noise areas. Various submitters highlighted gaps and issues of clarity, and in response, our recommended changes seek to provide clarity around the management within the high and moderate noise areas of the following activities. That is residential intensity in affected residential zones, residential development in other zones, alterations to existing habitable rooms, and the development of any other noise-sensitive activity. The submissions of Wellington Airport and others had raised concerns around the noise chapter's approach of using standards that mirrored the airport's noise-related designation conditions. In response, the 42A report recommended deleting or modifying some of the standards in contention, but adding a cross-reference to relevant designation conditions in Rule Noise R13. The airport company's evidence in chief appears to have largely accepted the Section 42A approach, but retained some concerns around the designation references in Noise R13. Given the airport company's general acceptance of the approach, the Council agrees it is not critical to retain the designation references in Noise R13. We also draw the panel's attention to App 4, Appendix 4 that is, of the district plan, which remains unchanged in the blue version of Appendix A. App 4 sets out tables of permitted activity noise levels by zone. This appendix was substantially changed from the public notification version of the PDP and is a key part of how the noise chapter works. It is of note that no evidence in chief from submitters sought further changes to App 4. Just some comments about procedure, Commissioners. For the remainder of the noise chapter hearing, we would appreciate direction from the panel about attendance of relevant witnesses, whether in person or online. At this stage, we're proposing in-person attendance on Friday and Monday, that is ourselves, to be present for any questioning related to the presentations of Kainga Ora, the airport company Waka Kotahi and KiwiRail. We propose to be available online for some of the other submitted presentations, being Guardians of the Bay, NZDF, the New Zealand Agricultural Aviation Association and Barnes. In developing his recommendations on the proposed district plan ventilation provisions, Mr Hunt commissioned and drew on advice from Owen Brown, who is a ventilation expert. We note that Kainga Ora has now lodged expert evidence from its own ventilation expert. We therefore seek leave from the panel to have Mr Brown in attendance to answer questions if required, that is, if he's available. We also seek leave to table written evidence from Mr Brown if that proves necessary. And just as an aside, makes sense to have Mr. Brown present when Kāinga Ora's ventilation expert is giving his evidence, which we assume will be on Friday. And finally, we propose that a relevant council noise officer attends the airport company presentation on Monday the 7th. The officers have specific experience related to the assessment of acoustic design certificates, which has been raised as a matter in the evidence of the airport company's noise expert. That concludes that introductory statement.
Well, and just in terms of your procedure there, from my perspective anyway, it sounds sensible in terms of who's appearing when and what and how. And certainly we give leave to have Mr. Brown come in attendance when KO's expert here. So that's fine. This is the end of the point.
Thank you, Commissioner.
Okay. Can I maybe just, because noise is such a fairly technical topic, could you maybe go briefly to your track changes version on the rebuttal? Just very quickly lead us through the main changes that have happened or are recommended to occur since the Section 42A report, just to warm us up to the topic, shall we say?
Yeah, certainly. So I assume you have the full thing in front of you. It starts kind of abruptly, looking like that.
Yeah, but the only thing that I don't seem to have it you can direct me to is the Appendix 4 of the Appendix A. So I've got the Appendix 4 of the Appendix A that came out with the Section 42A.
And that's unchanged.
It has no colour in it. So you said the significant changes, but there's no red.
Ah, well, there should have been.
It was a clean, because there's so much change.
Okay. There was substantial change. So, I mean, probably that should have all been in red, but
Oh, okay.
Yeah.
That applied to
it would have
what I was
been
asking for.
incredibly messy had we shown struck out as well.
Okay.
Yep.
So that, because that's why I thought there's no. Okay, that's it. That's the one we've got.
The-
Okay.
We might discuss that when we get to chronology.
Okay. All right, that's good. Thank you.
But,
It's worth its own discussion.
Yeah.
Thank you for bringing our attention to that, Commissioner.
Thanks.
So on the first page, there are changes made to the definitions, and some of these, well, I think most of them arise from in response to some points raised by submitters. The air noise overlay is an important one. The airport company asked that the air noise boundary be separated out and included as its own definition, which we have done. Added a definition of fixed plant. That was for clarity, because some rules do a fixed plant. And
Can I just pause for a second?
yes,
There's been, I think, thank you, about the overlay, the use of the term overlay,
Yeah.
overlays on overlays kind of thing. Can I just have your comment on that?
yes. Well, I mean, the air noise overlay as a whole comprises two parts. One
Right.
being the inner air noise overlay, and the other being the outer air noise overlay. And the separation between them, that is effectively the air noise boundary, which is a measurement line, rather than a noise control line. The air noise boundary defines where in 2050 it's expected that up to 65 dBA will be received on a 90-day rolling average.
Right. So in your view, there's no problem having this so-called overlays under overlays. Just a
Look,
semantics.
for the purpose of the people who are using it, I wouldn't have thought it created any real issue, to be quite.
Sometimes it's just necessary to refer to the aircraft noise affected area and use air noise overlay. But if you're looking at specifics around what insulation standard might apply, then it's broken down into those two parts. But it's really just air noise overlay is just a concept, and there's no rules or anything associated with it. It's only when you get down to the detail, inner and outer. That's where it's the road, is it?
But the inner boundary is the same
Oh.
as the extent of the inner.
Yeah, so
So why aren't they?
under NZS 6805, it's called land use planning and airport noise management, two different things. Land use planning is in relation to activities can take place in the inner or outer and ventilation standards and all of that. And airport noise management is only related to that air noise boundary. And as Mark says, it's a cap, sometimes called the bucket of noise. That's what's defined there. We have picked up, and a few submitters have talked about the outer control boundary, which is a concept mentioned in the New Zealand NZS 6805, but there isn't an outer control boundary in Wellington. There never was intended to be one. We're quite happy with the idea that everything controlled at the air noise boundary is sufficient to control noise as you go further out. My own view is it's really difficult to measure that far out. It's so contaminated by other sounds in the urban environment. So it's much better to measure at the air noise boundary closer in, and you've got a more accurate picture of how much aircraft noise is occurring. Controlling there will control effects.
Yeah, thank you.
Fixed plan. We, in response to a submission, we added a helicopter noise effects advisory overlay, and that is in the vicinity of Wellington Hospital. It's simply something which effectively alerts district plan users, to the potential for helicopter noise, and also one would assume appears on limbs where people a property search.
So do you have a timing on that work? I'm just, how long the overlay will sit there as just an alert to people buying a house or whatever.
Correct.
But there's work to be done to develop the vibration control.
No, that's the rail vibration.
Oh, okay. Oh, yes, that's right. So
Similar concept, in fact, same concept.
yeah. So this will just sit there as an overlay.
Yes.
Yeah.
So it's just advisory.
That's right. Yeah.
On that, because in the section 42A report says it could be seen as a placeholder or first step towards full application of NZS 6807. So is that the intention?
Well, it's a bit problematic because one never wants to control the amount of helicopter activity taken. Seriously ill people who are from the hospital. So we don't really know. And it looks 6807, the helicopter standard, is able to be implemented in parts. It's only a guide. And I would think any future development of the overlay for the hospital would be in relation to land use planning aspects of that standard, not the noise control aspects of it. So what we really are saying is that if down the track further investigations or indeed complaints or whatever might drive a revisit of that, it may lead to some who knows, insulation standard in that area. Could be that sensitive uses might need to be controlled in that close proximity. But at this stage, it's just a warning. We received submissions saying this submitter wanted to control the amount of noise from helicopters at the airport, and we said, well, that's not realistic. But we acknowledge the section 31 duty that council has to manage the effects of noise, and this is the first step on that. It is a pretty benign management thing, but it's the first step. Whether it gets any further or not down the track, it's up to those who assess noise policy and look at the effects and whatever. So it's just a placeholder.
Do you know if there are regular complaints about helicopter noise?
So my investigation, well, the officer will be the best coming along, but my reading is can get the 90 movements a month, and including through the night. And people, anecdotally have complained as far as I'm aware. So I think it is a fact that we weren't prepared to just ignore. And here is a benign planning method that gets at least the attention that if people are searching around and thinking of buying a property near the hospital, that might come up in the limb if they ask for one. So that's where that, and don't have any submitters talking about it, so it is appropriate now to discuss any details of it because it won't come up again.
By way of further clarification, the proposed district plan does specifically exclude emergency aircraft / helicopter movements.
Thank you, sorry.
That's okay. The next two definitions relate to the noise areas, which I referred to in that introductory statement. And these define the high noise area and the moderate noise area. And these they are what they say on the label, really. That they are areas where people could expect either high noise or moderate noise. Obviously, people's definitions of that might vary, but I mean, I might leave it to Mr. Hunt to explain what the background to that is. The high and moderate noise area.
Oh yeah, so we already had in the plan zones grouped into high and moderate noise areas, and it was planning witness for the airport that suggested, well, rather than listing these out, why don't we just call them a moderate noise area and high noise area? So that was a convenient thing that we latched onto as more as a naming convention, but the principles of having high noise and lower noise has been in the plan since originally notified. I know we're not really talking about the airport at the moment, but there was only ever a high noise until the proposed plan came out, and it was decided to further implement the recommendations for decided to have that moderate noise area around the outside of it. And apart from that, you had high noise areas near the port and Portney Place, which required higher standard of insulation than moderate noise areas. So the principles are already embedded indeed in many of them in the operative, and then enhanced when the proposed was notified, and really this last sort of piece of the jigsaw fell into place quite conveniently. So I think it'll make it easier for users of the plan to follow what's going on, rather than go through a list of zones.
Is this a fairly unusual approach across New Zealand, do you know?
Yeah, I mean, each plan's sort of different. But I would say it is a common thing to have more restrictive planning regimes in higher noise areas and less noisy areas. And also, I think it's a situation where you're trying to match the mitigation of the controls to the amount of the effect. And so, to my mind, it's a logical approach that in theory is found in other district plans, but
it's as an example of it. I mean, it's certainly concept is applied to the larger airports in the country, and even as an example, the Auckland Unitary Plan, it's referred to as the high air noise area and the moderate air noise area. So there are some definite parallels there.
Just a quick, this might be a planning question, I'm not sure, but is railway designation the same as railway corridor?
Yeah, I think we've probably used that term a bit interchangeably.
Because I know in your handout in 7 you say introduces a definition which would apply to either side of the rail corridor. Is that the same as the intent of that? The rail designation?
It is.
Oh, yes.
I mean, and yes, when we speak about rail corridor, we mean designation.
Yep, cool.
You'll see there on the next page over the rail vibration advisory overlay, same concept as the heli noise one, and this. Just building on Commissioner Faulkner's question, applies to a distance of 60 metres beyond the designation boundary of. You can see we also had deleted the Wellington Noise Management Committee. That given that that's well covered, by the airport company's designation conditions. That really does not need to be district plan. There are minor clarifications on that same page. I'm now turning to the page which is the start of the noise chapter. Again, some minor clarifications on that first page. In the box near the top of the next page, there is an addition there, just providing some clarification about Wellington airport noise. I believe that one was provided to us by the airport company themselves. Well, that or similar wording, and it does make sense to provide that kind of explanation there. But I think given that the airport is probably the major noise source within the community.
It might be a good point for a broader question. The airport are challenged. Can I ask why do that and not just depend on the normal noise standards that underlie the airport?
Yeah, Commissioners, it's got a somewhat complex history in relation to timing. Several years ago, the airport company went through the process of designating its land. Prior to that, airport noise was simply controlled through district plan provisions, but it had no designation in place, which was somewhat unusual for an airport. At the same time, and post that, the recommendation of the panel and the airport company's decision as a requiring authority was appealed, and that appeal was in progress while preparation of the draft proposed district plan was moving ahead. And moving towards the notification of that. So it was belt and braces really, because it was not clear what might come out of the appeal process. So to cover all bases, the decision was taken rightly or wrongly to effectively mirror the designation provisions in the district plan. That the decision of the Environment Court, or in fact the mediated settlement by the Environment Court, resolved the appeal shortly before the draft district plan was notified, but not in time for any changes to be made to that chapter, and of course, subsequently submissions received, etc. But I think via the submissions process and the council's desire to maintain some degree of control where noise is emitted by third parties within the airport designation. I think we've got very close to a position where the council and the airport company agree on what might be in and what might be out in those standards. The ultimate driver has been the council's desire to maintain that ability for easy compliance, where even though some noise comes out of the airport designation area, it's not actually under the direct control of the airport company. There are, as you'll appreciate, there are many different operators at the airport. The biggest and most obvious one is the airlines themselves. But there are other operators. I mean, there are car hire companies. There are all kinds of things there. So the council, could take action by trying to get through while trying to do that, but for greater certainty, wanted to preserve that ability to take action for third parties. So the provisions that we have tried to keep in the standards of the proposed district plan are those that clearly relate to third party activities.
I'm still not absolutely clear on what, because the airport themselves they control aircraft movements. Ultimately, they control all the aircraft movements and activities on the airport, I understand.
Well, we could provide an example of that by talking about the curfew, which Mr. Hunt mentioned.
Okay, yeah, I'll be interested in that.
So this is going back in history somewhat, but the airport company were quite prepared to allow some 10-minute relaxations if a flight was arrived late, and then certain operators decided that would become the norm to breach the curfew at night by 10, 15 minutes, and that was unacceptable to so the residents group are really switched on group, and they had their own little election to represent them, and they're on that air noise committee, and that was unacceptable. Council's on that committee and said, well, we'll take our own action, and they prosecuted certain Australian airline for breach of curfew, whereas the airport company would not.
Isn't that a designation enforcement issue in terms of conditions and things? Now that there's a designation fully in place.
I think well, first of all, it is about the sole focus of council's legal counsel when he comes along.
Right.
I think they foresee more direct part in some situations might be more appropriate than the long-winded going through the airport company to achieve that outcome and or whatever it would be. And I mean, to my mind, and I can talk about my 20-odd years ago history with it, it's about having some understanding and faith that the community can have if the airport company don't do something. You've got council there providing sort of shotgun to be able to be, if they can. And now it's really, as Mark says, there's really only a few that are left in the plan, almost all in the designation. So it's been a process through the submissions and discussions to get it down to what it is. But we've put our best foot forward, and it's up to the hearing.
What about the application of the general district-wide noise standards underneath the airport, across the airport? That still applies?
So they have, so the district-wide don't, of course, deal with the aircraft noise, they're exempted. But in terms of, say, land-based noise, the airport zone has its own, the designation, sorry, has its own requirements there. So there's no sort of gaps in it. And
but the underlying zoning rules and things, if you lifted the designation off, what would control noise?
Well, for just in terms of land-based noise, yes, there would be. That
Mr. Ashby referred to, say, rental car activity and things.
Yes, and particularly across the boundary of the airport zone into residential, that is the case, that you would be able to control that
through the normal district-wide standards.
Yes.
Okay, because I am interested in pursuing my understanding about the need to have a duplicative rule or standards underneath the designation conditions.
Yes.
I may follow that up with Mr. Whittington.
Yes, and yes, we've got to a position where there's a limited amount of that. And I refer you to the Section 42A report and paragraph 197 of that, where and this is just drawing your attention to the fact that an enforcement order can be sought for compliance in relation to a designation, but that requires the council to instigate an environment court process. But in contrast, seeking compliance via an abatement notice requires the offender to either comply or appeal. So, that's it's, well, call it a difficulty of enforcing on third parties via designation compliance. It requires an environment court process, whereas it's simpler if you retain that abatement notice power.
Any questions? Okay, sorry to interrupt.
No, all good, all good. Changes to noise 01. That's put the emphasis on management of adverse noise effects as opposed to where it was, where it was talking about amenity values and health and well-being being protected. Management is more the approach taken. I mean, there's certainly elements of protection in the proposed district plan provisions. There are the standards, provide the degrees of protection, but there are no prohibitions. Noise P3 has been amended to now to the high and moderate noise areas. Noise P4, both Noise P4 and Noise P3 have substantial changes which reflect the use of that shorthand for high and moderate noise areas. So that's where a substantial amount of the deletions in those policies comes from. Noise P6, again, some references to high and moderate noise areas. And then really we get to noise R3, where okay. And you'll note that in noise R2, there's an and being substituted for an or, which definitely changes the interpretation of it. Noise R3, look, big changes there, and very much responding to concerns raised by submitters in a bunch of areas, and it had been a difficult drafting exercise, but it now works through. You'll note there are two permitted activity rules or sections there. So there's 1 and 2. One relates to the activities within the high noise area, and 2 relates to activities within the moderate noise area. So that's an important distinction to remember. And as permitted activities within each of those areas, it specifies the degree of residential development. It is permissive of residential units within the Courtney Place noise area, because that in itself is a high noise area. And it permits alterations and additions to existing habitable rooms. Although you'll note, as is typical of I think all chapters in the proposed district plan, there are references back to compliance with standards. So the compliance with noise S4 and noise S6, those being a permitted activity here is predicated on complying with those. Noise S4 relates to acoustic insulation, whereas noise S6 relates to ventilation. And there are 2 acoustic insulation standards, one for the high noise area, one for the moderate. The ventilation standard is common everywhere, isn't it? Yeah.
Just as a general question, when I've seen all the changes that have been made during this process, is how, in your view, how do these sit well with the desire to intensify, so that the national direction of intensification and permitted is only 1 unit, albeit that they have to meet the insulation and ventilation standards? How do you think that you balance that?
Yeah, Commissioner, that's a big question, and really that lies at the heart of noise R3,
Yeah,
and
and
it absolutely lies at the heart of submissions from the airport company, from Kāinga Ora, from Kiwi Rail and Waka Kotahi, and the views are diverse. You have, let's say, the airport company at this end, Kāinga Ora at this end. We, in developing this, absolutely recognise the NPSUD and the desire for intensification. But and it is true that that you can achieve a lot with acoustic insulation and associated ventilation in some cases. But at the same time, and the council's recognised noise within the airport overlay area, but within the inner noise area as a qualifying matter. At the same time as you want to enable intensification, we think there does come a point where we need to limit the degree of that, rather than exacerbating existing reverse sensitivity issues and potential adverse effects on the residents who might be living there in future. The noise R3 as written still allows a degree of residential and intensification. For instance, while in the high noise area, which is the inner, as an example, the inner air noise overlay. This is the area where anything from 65 dB to 72 might be experienced, and that's on a 90-day rolling average. L max levels much higher. So in these circumstances, you absolutely need to keep in mind that seeing a figure which is 90-day rolling average, quite different to L max, which is a far bigger impact, and that impact will only grow with time as frequency of flights increase, because the airport's designation, and the contours in the district plan, are all heading towards growth of the airport between now and 2050. In terms of both physical growth, but also the frequency of flights. So this is certainly in relation to the airport overlays. This is an area in which it's not static. It's not a static noise environment. So that's some of the justification for limiting the degree of residential intensification. And the airport company still thinks that we don't have it right. They would like to see greater restrictions on it, whereas Kāinga Ora thinks we don't have it right because they would like to see virtually no restrictions at all. I mean, that's probably mischaracterising their submission, but
well, they do make the point that these two activities have coexisted for
absolutely. And look, I absolutely understand that. I mean, there's been an aerodrome there, I think, going back to the early days of air travel, and the community and the aerodrome and then the airport proper have effectively grown up together. So yeah, I mean, Kāinga Ora absolutely have a point in relation to that, but that doesn't get away from the fact that there is noise. Some of that noise, all of that noise can be controlled to a degree by acoustic insulation of one standard or another and associated ventilation where needed. So ventilation, by the way, is needed so that windows can remain closed, which is an additional aid to mitigating outside noise. But even with those, to my mind, and I think to the minds of my colleagues, there comes a point where, you know, you do need to keep a cap on the degree of intensification.
And just in relation to that, there's the outdoor. You can't insulate the outdoors too much. So is that that's part of your consideration in terms of intensification? I mean, where do you put that?
Yeah, look, outdoor noise. You're right. There's almost nothing you can do about that. I mean, you know, some submitters have talked about you know, design and layout of buildings, which can assist. I mean, but in relation to air noise, very difficult. You know, so you are left with that conundrum of outdoor amenity.
So, and just in terms of the internal, so your view that even with the insulation and ventilation, it gets to a point that it can't. You're thinking it's because you on the face of it, you've got insulation, ventilation, where you can intensify all you like.
Yeah, well, yes, that is a point of view, as I say, of Kainora. We're of the view that you need to, you know, moderate that. But it is dealt with differently in different places and in different jurisdictions. I mean, for instance, I mean, it's really interesting. I had a quick look at it, but the provisions in the Auckland Unitary Plan around Auckland Airport, they actually prohibit residential development. Well, they say new noise sensitive activities, but actually in one part of the moderate noise area, their moderate noise area overlay, let's call it that. It's not called that in the unitary plan. Relates to the Flatbush area, where you know, yes, you have to apply for consent, but 2 or more unlimited number of dwellings can be built, provided it complies with the particular density and other standards relating to that area. And those standards are very permissive. It's an area in which you get apartment buildings, you know, terrace housing, you know, essentially, you know, high density development, you know, down to sort of, you know, 150 square meters, you know, per dwelling. Yeah, so it's and possibly the unitary plan in that respect, you know, maybe that was compromised position to allow that kind of development. But you know, there's no, I don't think there's any right or wrong approach. You know, it is varied, and there are, I mean, across New Zealand at different airports, there are similarities in approach, but there is no one size fits all. So as I say, we've looked at it. We acknowledge the need for intensification, but we also think that there do need to be limits on it.
No, there's no science. There's no science behind trying to find that compromise, as you call it.
Well, except we seem to be focusing so much on reverse sensitivity. We danger of losing sight of the effects on people in their homes. That's the critical thing. Yes, sometimes they can get annoyed and complain, and then there'll be some subsequent downstream effect that may affect the operation of the airport. But and the guidance around outdoor noise levels that people should live in, it says, and I note the standard is 1992, so it did come out after the RMA, but I'm pretty sure they didn't align the word prohibited in the standard with the definition under the Act. But it does say that the guidance should prohibit further development of sensitive uses inside the 65. But Wellington is a special case, and that was acknowledged right in the operative plan when they decided to adopt the concept of 6805 and adapt it for Wellington. And it was the right approach, because you just couldn't. 6805 was designed, if you had a greenfields airport, you would follow that standard pretty closely. But of course, in Wellington, juxtaposition of noisy and sensitive uses. And so this is a natural development of it, but I think we get back to the idea of how to manage intensification in that high noise area. It's obviously, replacement of existing dwellings, if one burns down, you should be able to replace it, subject to insulation and a limited amount of additional, residential or sensitive uses. It needs to be managed carefully because, although I'm aware of the effects on the operation there, I'm more focused on these people that have to live there or seek to live there, perhaps without full knowledge of what it is like there, and that their sleep might be interrupted from time to time.
But just to follow up on that, so is the concept is you can allow a certain population of people to live in that environment, but not too many people to live in that environment. In terms of some people will live in that state of healthy or unhealthy environment, whereas not too many people should live.
Well, I think it's a probability factor in there with it. If you get more density, probably you're bound to get those community concerns growing and then actions that may eventually inhibit the operation. If you can keep it down, particularly the history you've got there and the way it's well managed. Now, I can't emphasise enough the wisdom of Judge Kenderdine when she set up those the Air Noise Committee and the investigations that were actually ongoing for several years after that committee was set up to try and, for example, work out what should the land uses be around the airport, how should the ventilation and insulation be handled. And so we came to it. I think it was a good sort of compromise situation, but yeah, it's not black and white. Obviously, existing uses are there, and they're kind of used to it. But you'd be very cautiously allow for further intensification in that high noise area.
Ideally, in an ideal planning world, you'd convert the inner noise boundary area to industry or something like that, and move it away from residential.
Yes, and interestingly, in the really, really high noise area, so this is 70 and above, that has taken place. The airport's gone out and purchased properties when they've become available and retired the land to some non-sensitive use. So, to be honest, I can never see that going to 65, but they do have this thing, and we'll hear more about it, called the Quiet Homes Program. And I have to emphasise that it's not a council-driven thing. It was an undertaking between the airport and the community. It is mentioned in the designation, but only to sort of give some backstop that it will happen. It goes on between the airport and the community, and they work out which houses this year qualify, and then you have to sort of put your hand up, say yes, I want it. And but look, it's a great way of just dealing with the existing residents and then trying to manage those effects on them by improving the ratings of their and ventilation of their existing homes.
Right. And just to return quickly to that probability factor in terms of health, so that if a certain population of people live close to an airport, you're saying, notwithstanding acoustic design and trying to make sure there's a acceptable outdoor area with acceptable outdoor amenity, notwithstanding those, you would expect some longer term health issues for that population that do live close to the airport.
Well, I have to differentiate between existing population and new ones coming in, because they would be better protected. And there's been some studies done as a part of that land use study that how good are those existing dwellings in the air noise area, high noise area. And then they're old weatherboard houses. Some of them are really not very good, and other ones are quite good. So it's those people. So that's not to do with intensification. That's to do with an existing population and an incremental growth in noise over time. That's where I see the main issue around often.
And that's notwithstanding all the acoustic and say new buildings.
Yeah, so the new building people would be better protected, but it is often the metric for how acceptable noise policies are is that you measure percentage of high annoyed, how many people are highly annoyed. Our correlation between highly annoyed people and experiencing poor health outcomes. So lower the percentage highly annoyed, to some extent will manage the noise effects, but Yeah, I mean, potentially it is an unhealthy arrangement, but it's the best compromise that could be reached. And then with environmental treatment of existing dwellings, which the airport's undertaking to do, and the district plan requiring all new developments, the wider area to be insulated and ventilated appropriately, I think it strikes a reasonable balance, and where it's ended up. Unfortunately, we're quite all on the same page around how to specify acoustic insulation. We'll get along to that in due course. But the principle is we all agree that new sensitive uses need to be acoustically insulated and ventilated. Actually, ventilation's gone from not much requirement in the operative plan to something quite, well, we'll hear from the experts, but it's quite a good standard. So we just don't want, they can open the windows to when they burn the toast, but for day-to-day use, we don't really want them open. This lets the outdoor noise in and undermines the whole purpose of insulating a dwelling.
On that point, I will ask at the end of this session around noise whether there's any value in us directing some conferencing around the acoustic insulation standards and things, or whether they're so disparate at the moment that is not viable.
Thank you. It's come up with the legal submission from the airport. So maybe that could happen too. But look, the council have gone down this track with standardised level difference. It's just a method of specifying the building envelope. Since Plan Change 23 in 2003, we sought scientists to be involved because we needed a rule, and I was thinking the council at that time that the rule could be implemented appropriately and then checked and measured if necessary. And quite honestly, the indoor DBA method, which is what the big transport seem to promote, there aren't appropriate standards to check compliance, but perhaps more importantly for the implementation side is that we sought a compliance pathway which would allow for a standardised construction. If you just followed this standard, this schedule, that's an acceptable solution in terms of meeting the insulation. You don't need a specific costly noise report, acoustic report. Just follow the standardised method. To me, that is such a key thing. And in fact, now we've got somewhere down the track, I noticed that the airport in their post special S16 or 17 that for airport noise is that they have adopted the schedule that is inherent in the other method that the council promoting, and that's not quite right because they've adopted the moderate schedule into the high noise area, so that's not going to give us outcomes that we're particularly happy with. So there's a technical argument, but also perhaps importantly, what we're asking for is a higher standard of insulation, so it'll be more protective of your place.
And how much more costly would it be?
Well, there's some information going over on that, but so Plan Change 23 in 2003, we had a quantity surveyor evaluate the 3 or 4 different scenarios, one apartment, one proper dwelling, adding a bedroom onto an existing dwelling, and we went through it all, and it's between 8 and 12% increased. So that's the standard for the moderate noise area. We haven't got an evaluation of the high noise area, but it's already been adopted into the operative plan in relation to port. I think there are 2 or 3 examples where there was just some subjective evaluation of the costs given at those hearings. So both the moderate and the high noise insulation standard have gone through some kind of evaluation by planning committees and found that the costs and the benefits, I suppose, of doing that, of adopting that approach have met an acceptable example. Yeah, the Courtney Place one, it's come up relatively recently. So the plan changes with 23 and then 72 and 73 brought it into centres and residential areas and got closely scrutinised then. In fact, it was approved by the planning committee that standardised level difference approach that the council wants was approved for the airport noise affected areas, but it was appealed and gated out in 2014, and back to the indoor LDN standard. They did recognise that at the time there was indoor 45 LDN, and they changed it to LDN 40 as a measure to try and sort of make it a little bit better in terms of protection. But there are a whole lot of council-based reasons why it's just we can't enforce it, we can't measure compliance, and I feel it's about time we put the council first in these things. We need a role that will give health and amenity outcomes indoors that we're looking, and it can be checked and monitored, and the compliance schedule approach, which is the compliance pathway. There's so many benefits of this thing, but we're getting resistance. And interestingly, so the airport would prefer the indoor LDN method. Kiwi Rail would prefer an indoor decibel method. Waka Kotahi haven't submitted against the approach council have, and I see that as a big tick, because I think they realise that, okay, so they don't have to pay for the insulation. The insulation is a better standard and it'll be a better protective outcome for that highway operator. And I really am thankful that I've seen the light, as it were. Although I do want you to have a look at the rebuttal evidence of the airport's noise expert, because he's saying that Waka Kotahi are promoting an indoor decibel method, which is not. I went back to the original submission, and they're quite accepting of S4 and S5 of those moderate and high noise insulation standards that we're promoting, and they they've accepted. Well, I mean, their submission is not seeking any change from what was notified in that area, but I do notice that it's a little bit tricky because Waka Kotahi and Kiwi have got the same noise expert, and he's a little bit sort of like he's supporting that one, but he's silent on Waka Kotahi because they've accepted the council approach. So it's a little bit messy, but I'd like it acknowledged that Waka Kotahi haven't submitted against the council's approach for insulating high and moderate areas, and they are a major submitter on all district plans up and down the country. And they've always gone for decibels indoors, and so here they've come along to Wellington. They had a good look at what we were proposing and submitted against it. So it's really just left with the airport and Barnes, of course, I think they would just want the same indoor decibel method up and down the country for whatever reason.
Well, that's what I was just thinking about asking you, and I don't know if it's a fair or unfair question. What is driving the push? If we accept the advantages that you state around this other method, what is driving the push for keeping the indoor decibel thing? Is it cost?
Well, they don't pay, well, except for that small bit what they do with Quieter Homes program. But that's already on a divergent path, because that's indoor LVN 45, and the standard for new and altered houses is actually LVN 40 anyway. And it's not a council-driven thing. We're very supportive of it, but we don't seek to influence it anyway. Right. We just want to go down this pathway to get a better standard in place. But getting back to your question, look, I don't know. It's always bugged me. Why? But I think the reason is that all you have to, in theory, I think, well, let's back the truck up a little bit. Planners, they're great, but honestly, they see 40 decibels in the door, go, yep, that looks pretty good to me. Well, actually, it's not, because of those issues around can't check it. There's no compliance schedule. It's a bespoke for each property. And I think there's planners out there that think that all you have to do is go indoors and measure, is it 40 or not? Well, actually, the LDN is a 90-day LDN 40. So how on earth are you going to check that? And then I've actually had to check some indoor road traffic noise levels that were based around the indoor 40 decibel limit, and I couldn't just measure traffic noise because there's other things happening, because you have to measure for the whole day. So compliance assessment is just a nightmare. But I feel that strategically, I think they feel that they could just go into the room and measure 40 decibels and say, well, not our problem, you haven't insulated your house properly. I don't know, but perhaps that's in there somewhere.
Yeah.
Seeing as we're kind of talking at a strategic level as well, one of the queries that I have is, you earlier made the comment about, it's actually about the effect on people rather than being focused on what reverse sensitivity is or isn't or does not look like. The proposed changes that have come through that we're talking about now seem to me to be a little bit opposite to what you were referring to, and in the sense that if I just took the two noise 0102, the objectives, I look at an objective and think that's what the policies and rules are designed to achieve. That's our end games. And so the changes in 01, adverse noise effects on amenity values are managed rather than amenity values and health and well-being are protected. It kind of leads me to believe that's a very difficult thing to measure. How do you measure the adverse effect of noise on an amenity value? And I don't disagree, I may not disagree with it, but I question how that helps us achieve the broader outcome where, and if we look at, you know, health and well-being, or sorry, health of people and communities is provided for. When I read through the suite of changes, it doesn't clearly align where the policies and rules do that. If that makes sense. So the policies and rules are very much 40 dBA, an area or something, but and it may be just my reading of it, but if amenity value, whether it's protected or is managed, the effects are managed, it's not clear to me how they are, how the health and well-being is provided for, all those effects are managed. In which case, does that then point us to needing a bit more to understanding what those values are and how the suite of policies and rules and standards achieve that? Or am I, this might be more from stage, or am I reading it wrong in saying that it does become more about kind of looking at the effect, even in 2, you know, when they generate higher rather than high. Higher than what? So what is higher?
Yeah.
You know what I mean? And so I now I'm not saying high provided the same period, but do you feel in the suite, I suppose my question is, do you feel in the suite of changes that we've got that we are walking towards achieving the things that you talked about earlier, in that it's about the effects on people rather than what reverse sensitivity actually is? Because that's the elephant in the room in this whole noise thing, is the reverse sensitivity, and you know, and so when I look at that, I kind of think, does that get us closer to what helps us understand the adverse effects on amenity?
Well, I feel we're walking towards better health outcomes for people and their values around amenity that they value. But it's a bit like walking through treacle because of these reverse sensitivities. There's huge,
right?
You know, just look at how many submissions and who's engaging all the legal advice and that. It's all about reverse sensitivity, and yet that term doesn't even appear in the Act. It's an adaptation of the environmental rules around to protect infrastructure or whatever. And we're battling towards better outcomes for people. There's no doubt. And at the same time, I believe if we're doing that, we're also addressing reverse sensitivity. But we're not, you know, we're not ignoring the need. And obviously these changes have come about through submissions. So when hired, you know, changed to hire, that was a, you know, an operator of that wanted that word, and we, you know, so we have to compromise in various places. And but I agree. Look, if we did this correctly, we would put, you know, reverse sensitivity, addressing reverse sensitivity should be an objective. If we're that subject to this huge tide of effort to try and influence the district plan to protect these infrastructure, we should do that. But to my way of thinking, we are striving towards protecting people to a better standard, because I think we can afford it, and the implications are not great now. Okay, yes, we talk about costs increased for building, but hey, that's a price of living near the airport and the lovely convenient spot that it is. It's noisy, so you have to address that. So yeah, I think personally, with the way we've couched the rules and then amended them through the submissions received, we are driving towards improving outcomes for people, that we can't ignore this whole process.
And Commissioner, that I think really is clearly signalled by those two objectives. One dealing with management of adverse noise effects and providing for for the health of people and communities. But the other of the two objectives is specifically about reverse sensitivity. So that need to play off each of those objectives throughout the chapter is it's trying to get through that treacle that Mr. Hunt was talking about.
Thank you. It's useful.
Just when you first started talking about health, you referred to a document or a standard which talked about the health standards.
NZD 6805, the
Oh, it was the
airport noise
6805.
standard.
I
Yeah,
thought it was something
for
else.
health reasons, it says prohibit inside the 65, but it's a generic recommendation, and standards are only idealised and then they adapt to circumstances, and that's what happened in the operative plan and sorted out that way. But yeah, people are living in areas which you really wouldn't want them to, but
Yeah, so it's that standard. I thought there was some other.
no, well, that does reference through that standard some World Health Organization, so it does have that international research kind of background. But even the World Health Organization, they are generic things, and they're always intended to be fed into a process where you look at local competing needs and all of those other factors that need to be weighted up. So I don't think anybody's just mindfully follow the World Health Organization to the expense of everything else. We're trying to sort of find that balance ourselves.
Yes, I was just because it's right. We're talking about reverse sensitivity a lot, but it actually goes back to the health effect.
Yeah, I think that's right.
Can I just take the opportunity to clarify about 6805? That historically, it's been used since 1992, obviously, and it does have those aspects to it. It's it's about measurement. It's about guidance on land use planning. The National Planning Standards has, I guess, chopped that in half. The National Planning Standards mandates the measurement aspect of 6805, but not the land use planning aspect. So even though the land use planning parts of 6805 has influenced district plans across the country since 1992, in that respect, that's to my mind no longer really on the table. I mean, it's useful history.
My view is it still remains a red covered standard which has standing. It's an other matter, can't be disregarded, and in fact it'd be impossible to implement NZA's the land use planning aspects of 6805 because it says sensitive uses are prohibited, and LMRE just couldn't conscience that. So it's still a standard to be followed. It's got merit. It's just that if you mandate it actually is only the quantification and the measurement aspect of it that's mandatory, but the recommendations around land use planning still sit there as very valid and appropriate.
Could I just, I was interested in your comments about reverse sensitivity, just generally as well. And very first hearing was about strategic objectives, big section on there and infrastructure. And just looking through, there's definitely a strategic objective relating to reverse sensitivity. I know there were submissions on it. Infrastructure operates efficiently and safely and is protected from incompatible development that create reverse sensitivity. So at the highest level, it's recognised as an issue, and all the modern plans that I've seen, certainly with the infrastructure issues, reverse sensitivity is a dominant matter which is being considered at those. So I was interested in saying reverse sensitivity is not identified in the plan, or in the Act, but there's a body of case law and lots of definitions around, and it has become very settled, and the concept has become very settled in planning law.
If I could just comment back, so the legal advisor to the airport has said that we've gone soft on reverse sensitivity, which is complete not correct. When you look at the insulation standards that we want a better insulation standard, surely that's going to protect the airport to a better standard and address reverse sensitivity. But we can't seem to get any traction with them on that. So, you know, reverse sensitivity measures to address it are up for debate, and so, you know, absolutely accept that it's a principle and it's an objective to protect these assets, but you know, we need to do so in a balanced way and not just accept the operator's view of what's an adequate level of protection. So, yeah, I think the comments from the legal angle were that the land use restrictions weren't tight enough for them. But if you look at the broader picture and the technical aspects that I'm involved with, actually we're asking for a new and altered dwelling to be protected to a higher standard, which I would have thought ticked a few boxes with the airport company. But I think, as I mentioned earlier, perhaps they see some overplay between that and the quieter homes program, which would increase the cost to them, but that might be behind there. Anyway, thank you for that. I agree, it's an important objective.
I just as a comment for me, I see there's a fairly limited toolbox of ways to deal with reverse sensitivity issues. You know, one is management of intensity of development, and the other is relates to the construction quality of buildings. I don't think there are, you know, a great range of other viable methods for dealing with things. So it's really, as Mr. Hunt says, it's a balance between how you use those tools. You know, to what degree do you constrain intensity of development? To what standard do you acoustically insulate? And what process do you make people go through to you know, to try and do things that are outside of those standards?
Perhaps you would like to just carry on, just taking us through the changes. There's not that, I've just been flipping through it. Probably just highlight a few key amendments.
So are we done with noise R3?
For the moment. Yes. So I think we've been looking around R3. So I think it's about R4 basically.
Yes, and we've talked about the helicopter stuff. That note is there. Yeah, just it links to the definition and the advisory overlay. Moving forward, I'm looking for mostly the blue stuff. Did you want me to comment on the red stuff as well?
Only if you think it's pertinent to what we've been talking about. But otherwise, no.
When we get to noise R13, airport noise again, you'll see that that there's a bunch of blue crossing out. This was where there was reference to clients with designation conditions. That change has been made because now it appears that the airport company is reasonably comfortable with the remaining standards. So we see no need to complicate that further by bring back to those designation conditions. So that's gone. Getting through into the standards now, and S3 where there's reference to the air noise management plan has been deleted. Again, because it's well covered by the designation conditions. There's substantial direction in the designation of the conditions about the preparation of an air noise management plan and the formation of the air noise management committee, and any future changes to the air noise management plan. And just as an aside, the current version is very recent, so it's very up to date. But any future changes to it still need to be certified, and that's a designation condition. That's the council needs to certify any future changes to the air noise management plan. So that's just background to why that's no longer needed in S3.
It's not mentioned, but in R13, the reference to the airport zone 5, it says rail. That's still intended to be in R13. Yep.
Number 2,
restricted discretionary.
airport zone.
No, that should be out.
Yep.
Thank you, Commissioner.
So in the S3, oh sorry, in S3 you're just talking about, I don't see any changes to my one. It's just
Well, the entire section on airport activities has been recommended.
oh yes, sorry, yep, no,
That is correct.
yeah. Sorry, I was looking at.
Moving on to standard 4. This is, I think maybe Mr. Hunt, would you like to talk about that?
Yes, it goes to the insulation standard for high and moderate noise areas, and it basically requires in the moderate noise areas for the building to be constructed in a way that gives us outdoor sound by 30 decibels, and it actually it's quite a technical term, but it is the right one, and it is based on ISO international standards, and that's the reason by which compliance measurements could be undertaken to check that that standard was achieved. We and in the higher noise area, it's a 35 decibel standard, so it's designed to resist a bit more outdoor sound, and the analysis that's been done indicates that particularly say around the airport and in a city and high noise area, Courtney Place and Port area, the resultant indoor sound levels are good and protective and would meet most modern health standards. So, however, a couple of things came up when we were putting all this together, and one of them was the ventilation. So there's S6, which is a companion to S. If you're in the moderate noise area, it needs to be S4 plus S6. High noise area, S5 for the structure, and S6 for the ventilation. Oh, sorry, S4 for high. Yeah, sorry, the wrong way. The other thing that came up through submissions, and it was a good point that was made, was around the if you're adjusting and altering a habitable room by a small amount, if we didn't provide some kind of exemption, that part of the habitable room would need to be insulated to whatever standard, but the rest of the room wouldn't be, and it would be inefficient and unworkable, really. So we've I think that came along and suggested that, and that was a sensible approach. And I think they wanted 25%.
25 means squared.
25 as a quite a large area, and then another element of their submission said as long as it didn't increase the bedrooms by more than one. So we having a look at that, we said, well, actually that seems quite a large exemption area, adding 25 square metres to a habitable room, and also we just prefer that if there's to be any new bedrooms, that they'd be insulated to the right standard. So we pared back the exemption to something that's reasonable and in fact consistent with a lot of district plans have those requirements, and so you can like just change a window or a small area of a habitable room and be exempt from that insulation standard. So that was about another angle to that compliance pathway that we thought, well, don't want unintended consequence, and implying all these costs would be needed and it wouldn't achieve anything indoors, because what's the point when the rest of the room is back at its original acoustic standard, and it makes sense to insulate the new addition in that small way. So that's
the wording of that number 2, the new number 2 there, doesn't quite work. I don't think it. What is it trying to do? Is it trying to exempt less than 10% gross floor area addition from
yes,
requiring?
so they're a list of permitted activity standards.
Yeah.
And the second one says it's less than 10% of the gross floor area, then it's exempt.
But it doesn't actually say that. It doesn't actually say it's exempt.
And one
does.
Yeah, and one it says except for provided as in 2.
2.
Yeah, which could probably be more clear. Yeah.
Yeah, I think the sentence, maybe lose the which, maybe even. I don't know. I'm just putting that there.
Yeah. We'll come back to you with
Okay.
those on that.
Thank you.
What happened was we actually adopted the anger or wording and just tweaked the numbers, but we obviously probably should have rewritten it.
Do a word search for enmity as well. Noticed that a few times.
Yes, if you lost the which.
Yeah, I think, if you just delete
Then
which,
take out the
I think
word which.
And what word were you talking about, Commissioner?
which in 2.
But you said do a word search for.
Enmity. ENMIT. Look on the other columns.
The other column
And
number
then,
2.
and yeah.
Oh my goodness.
And
Yeah.
that's several places.
Okay,
That's just.
thank you.
Yeah. Okay. You want to just carry on leading us through the charge?
Yeah, so, well, that's taken us through S4 and S5.
So a few words about S6, because there's been a few submissions in support and against S6. It is a step up from the operative plan, which just basically required a little bit of fresh air, and now we have thermal requirements and a what we call a room flush. So you should be able to dial it up to 6 air changes per hour if you want to. Although what we're saying is actually that shouldn't necessarily be the case where you've got an openable windows that sufficient to comply with the building code for ventilation. Those openable windows are adequate for room flush. It's a now and again thing. You don't need a big grunty fan, just a little one. And so we try to get that balance right. And then the other thing about S6 is that the system itself shouldn't be too noisy because people won't use it. Some submitters have said that relatively low noise, it's quite a quiet sort of requirement, should apply right across the operating range, including up at the 6 air changes per hour. And we've got this engineer guy who's going to come on Friday, but he was saying, look, the cost of maintaining no more than 35 decibels at 1 metre up at the high ventilation rate will just drive the costs hugely, because to keep noise down you need bigger fans that operate slowly, and you need larger ducts so that near self-generated noise is minimized. So we have said, well, actually, we need it to be quiet, but it doesn't need to be quiet up at the higher airflows. They're a short-term thing. They're not likely to occur during the night time because you're not awake to adjust the system up to the high flow rate. And so again, we're trying to keep the cost reasonable. We had several submissions saying they like the idea of improved ventilation, but they were worried about the increased cost. So we tried with expert input, tried to find that balance to make the system user-friendly and practical and workable without the, the full bells and whistles. If the room's got enough openable areas to comply with the building code for ventilation, then that can displace the need for the high airflow, and you don't need the low noise limit applying right up into the high airflows because of the cost implications are disproportionate. So that's the basis of the recommendations. We will have on Friday, or just received advice that Owen Brown, the guy that I consulted with, will be here to answer questions. And we've got Paying Gore bringing along a ventilation engineer, which my quick reading of his evidence is that he's pretty supportive. There's a couple of tweaks in there, so I'm sure we can work through that and get to where we need to be, which is going to be a whole lot better than the operative plan, which I feel was the bare minimum, and we weren't thinking of all angles when that was approved, particularly around heating and cooling. So that's why we've gone to, it isn't expensive, and it will be more expensive to implement than the basics of the operative, but for good reasons, because what's the point of spending all the money on the acoustic insulation and then opening up windows because it's uncomfortable? That's the basis of that.
Sorry, I'm just keeping an eye on the time. Mr. Ashby, can you just maybe carry on, just lead us through?
Yes, Commissioners. In fact, I don't think there's anything else I really want to draw your attention to be honest. There's the deletions relating to S13 has gone, as has S9, but they relate to that issue which we've discussed before, and there are a few minor clarifications in blue, and that's really it. But obviously there's App 4, which you may, and App 5, which you may want to discuss.
I've got the notified in front of me version. Will you just lead us through that briefly?
I will leave that to Mr. Simon, actually.
So yeah, Appendix 4 and Appendix 5 permitted noise standards are pointed to by noise S1 and I think it's S7. S7 for Appendix 5, which is fixed plant noise. So this is, aside for say aircraft and other transport, this is really where the other side of, the non-reverse sensitivity side of things come in. The reason why we're talking about reverse sensitivity so much is because that's what most of the submissions are on. We didn't see so many submissions about this section of the plan, but there were some errors in omissions in the drafting of the permitted noise standards, which we've tried to clarify, because this is really important in how users of the plan will interact with the plan if they're setting up new activities or if there are noise complaints or anything like that. This is to do with the noise emission standards for permitted activities. So big changes that we've made in the structure of the tables and clearly identifying noise from which activities in which zones. There were quite a few errors and omissions in zones shown. Some zones were not displayed in the tables. Some zones were displayed twice within different groupings. The noise levels shown are in, I think, most, if not all cases, the same as those within the operative plan. We've not seeked to make many changes, and those that we have made changes on have been presented in the section 42A report. In some cases, those are to do with changes for activity to be a little bit more permissive on Sundays, I think, which is open space activities more permissive on Sundays, which I think was sought by the council. Apart from that, realistically, this is just a change in the way that it's presented in terms of the structure of the plan itself and how it's presented, especially in the E-plan, as noise itself is listed as a full chapter rather than noise standards presented within the specific, residential zones or centre zones. Noise as a chapter itself needs to have a table like this, which refers to all zones and all specific activities. And as I say, I think we only got one submission on this, which was from Woolworths, and they were pointing out that there was some, clarity missing from these tables, which pointed us to some of these errors and omissions, which really would affect how operators such as Woolworths, such as any sort of operator in any of these zones, would be able to set up their activities or even just run their existing activities. So this is really important for how the plan operates.
Sort of involved in drafting this, helping Sean, because it came to us as a shock near the end. We've been dealing with submissions. Nobody submitted on one submitter on what would normally be the crux of the noise chapter. How much noise can my shop make, or nothing? And yet, I forget who it was went through, and I think there were 10 bullet pointed problems and errors that really needed fixing up if this plan is to work properly for the officers as much as for users of the plan. But it does follow the operative plan as much as we could. There are differences that they are explained in the 42A report. The whole idea of open space zones being quiet on a Sunday, it was, it's just not a thing anymore. There's no guidance, standard, World Health, anybody that says you should limit Sunday noise to nighttime limits. And for the officers, it's a nightmare, because how can you measure compliance with a nighttime limit in the middle of the day when there's lots of things going on? And so compliance is always an issue, trying to assess compliance. And the last thing is we've kept the sort of fundamentals for the rural zone. So we assess noise at the notional boundary to rural dwellings. There are zone boundary limits so that the rural zone can't generate unreasonable noise within any other zone. But the premise is that open unoccupied land is it can be a reasonable mitigation measure. And it is in fact the approach recommended in NZS 6802, which is the general noise standard for managing noise in rural areas. So we've retained, all the sort of fundamentals of that, of the operative plan, and I think we've come up with something that's workable. And as I say, it was just a surprise for us to discover the inadequacies that weren't flushed out through submissions, and it was only we delved into it, came across it at the last minute. A whole lot of problems that needed sorting, but we've got there. So.
And scope, Mr. Ashby, for the changes to be made to the table, is that IPS?
As Mr. Hunt says, and Mr. Simon too, there was a submission which drew attention to the appendix, but as Mr. Hunt said, it largely takes through what was in the operative plan. So it's much more around clarity of presentation than anything else, and the And the other changes which have been described and are set out in the 42A report are pretty minor. And look, I mean, as both the experts have said, this appendix is fundamental to how the rest of the noise chapter works.
As presented in the proposed district plan that was notified, I would not be able to do my job as an acoustic consultant. With this as presented now, which is as you know, with the standards noise limits that are present in the operative plan, I am confident that we'd be able to do assessments, but there were too many omissions and errors and inconsistencies in what was drafted, and there would have been issues with assessment and compliance measurements, which admit that it was something that needed to be done. We did have a submission on it.
And there have been no, there have been no comments and rebuttal evidence about this version.
Okay, I will adjourn the hearing for a 20-minute break. Before I do, two matters. One is I'll repeat the question again, just to have you time to think about the value or not of expert conferencing outside this hearing, whether you think it's worthwhile, and if so, what the scope of that could be. The other matter, and I think it was in your report, your section 42A report, there was some mention made of the panel, if we wish to, commission a report around the road noise and rail noise things.
Rail vibration.
That's it, rail vibration. Well, speaking on behalf of the panel, with whom I haven't consulted, that's probably very unlikely we would do that given the time and scale of what we need to do in terms of the IPI process and just the time and the scale of work that would be required to achieve any outcomes that could be no plan change. So I just thought I'd put that on the table. After the morning break, do you think it would be, I see Mr. Wellington at the back there now, have him join us at the table here and just talk to his legal submission, and then after that we'll probably just wrap up the noise, any more noise questions and things before midday.
Sounds good.
Okay, well, on that we'll adjourn the hearing until 11 o'clock. Thank you.
But the positions are so
Good morning. Hearing stream 5 is reconvened after morning break. We are addressing the matter of noise this morning and had a good discussion before morning tea, and we're likely to carry on for the next hour on that topic. Mr. Whittington, we've read your legal submissions. You've heard some of our questions around the noise issue. Wouldn't mind just talking to your legal submission? It's short and sweet, so it shouldn't take too long.
I certainly can do that. So the main issue that I dealt with in my legal submissions was the duplication. Thank you. The main issue that I dealt with in my legal submissions was the duplication that the airport was concerned by. In that they have their designation conditions, but the plan duplicates a number of the standards that they have to meet. And the main reason that I explained for that is that the council would like to retain the full range of enforcement options. Prosecution, for example, requires, under Section 9, requires the prosecutor to identify the district rule that is alleged to have been breached. And so if the council found itself in a situation where it wished to prosecute a third party, such as an airline, as it has done historically, not very much in the recent past, but going back 15, 20 years, I think there were some prosecutions of airlines for breaching curfews and things like that. There needs to be a district rule that the airline is breaching. So for that reason, council wants to maintain some district rules that as Mr. Ashby has said, are targeted mainly at those third parties. Obviously, if the airport is acting consistently with its designation, and it's not at risk of any kind of enforcement action for that. That's really the nub of it.
So in a legal sense, there's no reason not to have it. There's nothing that in case law or anything that says that such, you call it a necessary evil, that evil is unwarranted or unjustified from anything. Because it's unusual for me, from my experience, to have come across a duplicative kind of condition underneath for this purpose. I haven't really struck it or remember striking it.
It may well be. The way I thought about it, I looked for authority.
Mm-hmm.
and could find nothing. And it may well be that, to the extent there's no duplication in other district plans, that if and when those councils find themselves in a situation where they want to prosecute, they're actually out of luck because their plan does not provide a rule that applies to third parties operating in the airport zone. And they may have some means of enforcement against the airport company to target the actions of the third party who is I suppose, seeking shelter under the designation, but they won't be able to target those third parties directly. That's on my assessment of, and there's someone who has taken a number of resource management prosecutions, identifying the district rule breached is important.
And you couldn't rely on a Section 16.
You potentially could. It depends on whether you want to run it under Section 16 or under Section 9. If it was, for example, about breach of a curfew, that would be a section. Perhaps you could try to dress it up as a Section 16 matter, but it's really about breach of a district rule, in my view.
No doubt we'll hear more about this as the hearing goes on.
Yes. My understanding is that other than one or two rules that may still be an issue, that the airport company is comfortable as they can be with the suggestion, unless I'm misreading Stuart's legal submissions.
Okay, any questions, Mr. Wellington?
Could I just ask, Mr. Ashby might be able to help as well. So what's in the designation conditions which is not in the district plan? What is the nature of the matters in the designation conditions which haven't flowed through to the version that we were talking about before?
So the ones which have now been deleted relate to measurement of noise, to hours of aircraft operation, I think that's correct. So things which are very clearly the airport company's responsibility. The things that remain are things that remain, as an example. Oh, yeah, sorry. Yeah, so, yeah, sorry, I misspoke before. Hours of aircraft operation, because that remains, because that is, in fact, third parties, that the airlines, that they're not under the direct control of the airport company. Also things like land-based noise, in general, noise from the Miramar South precinct. That is an area of land which was previously occupied by the Miramar South Primary School, I believe. Was designated maybe 3 years ago, has been cleared of buildings and is being developed for a range of uses, but things like rental car companies, catering, etc. And it's surrounded by across the other side of the street or streets by residential development. So those are all third-party operators. So that one in particular is a very clear example of their third-party control is actually, we consider, very necessary.
Thank you, Mr. Whittington.
Thank you.
It occurs to us there may be one or two other issues that arise during the hearing that might thinking particularly the whole thing around land issues on that. Maybe we'll leave it till we hear from.
Yes, so I think going issue by issue makes sense. I'm happy to address that issue. I have identified from the other submissions filed on behalf of Kāinga Ora, Stride and Argosy, and the other parties, some issues that I can address you on, but I think they should probably be specific to the issue at the time. I'm with trepidation suggesting that I could address you very briefly on the reverse sensitivity issue that's been discussed this morning with relation to noise. You may not be aware, I don't have instructions to talk to you about where the parties are landing on this issue of balancing the noise, the corridors in particular with Waka Kotahi and Kiwi Rail and the airport noise. But I can certainly talk to you at a high level on the question of the debate, I suppose, between Ms. Dewar and Ms. Chappell on one hand and Mr. Matheson on the other about reverse sensitivity, because I agree with what I heard this morning from Mr. Hunt about the way that the airport companies or the airport aligned companies are treating reverse sensitivity, giving it, I think, a significantly greater scope than it justifies. I agree with Mr. Matheson that fundamentally at its heart, what reverse sensitivity is about is equity. As Dewar says that it's not about equity at all, but the way I see it, what we do when we consider reverse sensitivity is identify the fairness or where the correct balance lies between protecting a piece of infrastructure from new uses and ensuring that existing uses have an appropriate scope to develop, and a balance needs to be drawn somewhere. that is fundamentally about equity and fairness. You could say the same about perhaps any resource management issue, but I disagree with Ms. Jewell that it's not about equity, and I agree with Mr. Matheson that it is about it. That's probably as far as I can take it, but as I say, I haven't got instructions to talk to you about how that then comes down at the next layer, and that's because this issue has been raised up and down the country in relation to different plans, and I've acted for kind of order in that debate. So the council's, I think, going to instruct somebody else if that's something you want to hear from the council more on.
Were there any other sort of legal matters that occurred in the course of submissions on this topic?
Not on noise, no. What I was going to say, perhaps just to tie that up, all up in a bow, was that I found a comment in paragraph 4.5 of the Barnes submission by Ms. Chappell. What she says, paragraph 4.5, is that she's talking about reverse sensitivity here. The imposition of operational restrictions to mitigate reverse sensitivity effects is not a strict requirement. Rather, the Environment Court has made it clear that the established use may be required to restrict its operations. And that, to me, confirms that this is about equity. They're not saying that where there is reverse sensitivity, that's it. No new or even existing activity nearby can be allowed to change. It's not a strict requirement. The airport in this company may be required to restrict its operations. No one's suggesting, of course, that they need to restrict their operations. It's about the potential risk for future operational change. But that is not consistent with saying that it is not about equity, in my submission.
So if it is about equity and striking the right balance, in your opinion, do you think where we've landed with regards to the recommended or proposed changes to this in response to the work that Mr. Ashby and others have done achieves that equity and balance?
I think that's a matter I can't really address you on because of the.
Can try.
Yeah, but yeah, so I can't take that any further. And just so you're aware, there is one other issue in this hearing stream where that is affected, and that's the argument by Cone Order about statutory planning maps, hazard maps, and whether they should be inside or outside the plan. I've had that argument up and down the country in the Wellington region, so I won't be addressing on that.
Thank you. Any other questions, Mr. Whittington? Okay, thank you very much. Mr. Ashby, I know we do have a number of sort of odds and sods questions and things, so this is something from the previous discussion you want to pick up on now?
No, I think it's open to you. If you've got some questions, far away.
I just have one as relation to NZ.
Commissioner, could you turn on your microphone?
Oh, sorry, I was speaking down to the floor. It was New Zealand Agricultural Aviation Association. It was your paragraph 187 in your evidence. It was about that helicopter operations for agriculture work may be covered by exemption 7, which says rural activities, including agricultural vehicles, machinery, equipment used on seasonal or independent basis in rural zone. And there's a bit of lack of clarity around the maybe.
I agree, and yes, I've read that in their recent rebuttal as well. And look, I agree. There could probably be some additional clarity brought to that.
So would you do rewording of that exemption, or
one of the remedies they suggested, or maybe it's a combination of, was to include a definition of agricultural aviation activity, and I think that could be quite valuable as part of it.
Yeah. Okay. Thank you.
Question while looking at the questions. The whole question, Mr. Hunt, really around live music venues, because both of you.
That would be my area. Sorry.
Okay, right. Your sort of experience to date. The question arises in my mind when I read that part of the Section 42A report was, could there be standardised rules around music or other sort of loud noise activities? I'm guessing they're covered mainly in the temporary activities, which is yet to be heard.
Events would be covered in temporary activities. Yes.
So, is in your experience outside the Courtney Place area, are there a lot of live music venues that could be bought by this?
So, I mean, we haven't proposed any changes, and we've suggested that there may be some scope, but Save Our Venues have, I think, maybe misunderstood what was in the proposed plan around sound insulation. There are some venues that are certainly outside of the Courtney Place area and the city centre areas and other centre areas which have sound insulation requirements through noise S4 and noise S5 in the proposed plan. The crux of it is, which isn't addressed in the State of Venue submission, is venues are still required, like other operations, to meet the noise emission permitted standards in Appendix 4, which are certainly at higher levels within city centre areas, for example. And one thing that may have been confused within their submission is that the Courtney Place area does not have a higher noise emission standard than the city centre area. Those are the same, which are set at 60 dBA LEQ, sort of your average level, and LMAX of 85. So the problem with venues in maybe more like local centres or neighbourhood centres, if those are the case, I'm not sure exactly what, say, something in Newtown would be zoned. If there are adjacent residential zonings, the venue would need to meet the noise limits as measured at that residential zone, which is not something that their submission has requested sought any amendments on.
Thank you. And it may be superseded by recent evidence, but Mr. Ashby, in the Section 42A report, in paragraph 160, you list out the definition of high noise area, and I haven't managed to in time to take that to the final definition, because there seem to be a few zones missing from that table in terms of high noise. The MCZ, the Metro Centre Zone, Centre, here to P4. In P4, what difference between the two?
So the zones that you've mentioned there are actually in the moderate noise area.
Yeah.
So there's, I think, some listed in the in P4 that I think P4 identifies both high and moderate zones. So is that correct? Yes.
Yep.
And that might be the issue there. Is noise P4 identifies both high and moderate zones, whereas the definition identifies those clearly within the groupings of high and moderate separated out.
Thank you.
just while the others are looking, can we have a talk about vibration? Particularly road and rail vibration. So your position is that it's too hard really to impose a standard requiring vibration sensitive activities to actually mitigate that source. Do you know what's happening in the space? Because I think we've been in a number of hearings over the years where this topic is continually raised and references to the Norwegian standard and that. So if things not actually progressed nationally in terms of getting something which is workable in relation to a consistent New Zealand standard?
I couldn't speak honestly to national. Just for some backgrounds, I've only recently started working in New Zealand after being working in Canada for about 5 years. I would not agree that it's too hard to mitigate at source. I would say that source side mitigation is the most effective forms of mitigation in most cases for both noise and vibration. In terms of why we're opposing it is we don't have sufficient data for especially the Wellington region to suggest that it is appropriate for the level of assessment that would be required.
So in terms of the mechanism, you got somebody who's wanting to develop residential or beside a railway line, for example. So you go through your LIM process and you actually have a look at what it says, and you get this overlay saying that within 40 metres or 60 metres, you need to be aware that you might be subject to rail vibration. So what do you do about that? You just say, okay, I'll take the risk and I just build a normal foundations, and or do you say, well, I might be subject to risk, therefore do a high level building in terms of foundation standards and so forth. So it's what I'm trying to get to really is what is the point of an alert if you can't do anything about it, or you choose not to do anything about it?
Yeah, that's a fair point. Yeah, as written, it's up to the site owner to determine which action they would want to take, and yes, it would appear on the LIM, but it would be up to the site owner to determine the appropriate action, if any.
Because doesn't it depend on a whole lot of factors that you don't know about, like ground conditions? You've got sandy or peaty soils. You might be, it would be different to if you're some sort of rock, and wouldn't it also depend upon the state of the actual? You take rail as an example. If you've got a new line and it's got new ballast on it and so forth, and you've got a whole lot of new rolling stock, for example, which was better cushioned. So doesn't it depend on a whole lot of factors, and what is the having some sort of alert on it? If you realistically don't have enough data or enough information to be able to make a determination on whether building your residential property next door is going to be.
Yeah, so our position at the moment is, and certainly those factors are one of the main reasons that we've taken that position. And as you say, railway vibration is dependent on ground conditions are a big component, and the rolling stock, the track conditions, where it's measured as well. But the wheel, whether it's freight or passenger rail is very important. Obviously the mass plays a huge influence, but those items are very maintenance, very dependent on the maintenance of the track, of the wheels, and of the rolling stock. What we don't see currently is any requirements or any provision. So if you were to meet the Norwegian standard, if you went to the cost of mitigating to meet the vibration standard, if it was exceeded, there wouldn't be any provision for the rail operator to continue to meet that at your mitigated building. There's nothing in place for them to monitor their vibration levels, and there's nothing clearly stated. We requested evidence of this and it wasn't really provided, that shows that they do maintenance based on vibration or noise, for that matter. So if the condition of the rolling stock deteriorates, vibration will increase, or if greater amounts of movements of greater rail movements near those properties increase, the vibration level will increase.
In terms of the overlay itself, you're going to be potentially putting some lines on plans and so forth. So, you know, we'll ask Dr. Charles this as well, but, you know, how much confidence is there that, you know, beyond 40, then any vibration effects, say in Tower, where you've got the main trunk running through Tower, how much confidence is there that that is good? A good estimate of where that 40 metres should be, or whether it should be more or less, or
based on what I've seen from Dr. Charles' evidence, I don't know. He's provided track measurements from various places in the country, none from within the Wellington region. It wasn't clear if they were from freight rail lines or passenger rail lines. There's not much for me to make a determination, say, for example, if what the distance should be from the Johnsonville line or from the main trunk line in Tawa. And that's why we're saying I don't believe there's enough information to determine that 60 metres from the rail line, every property within this distance should have to do a full vibration assessment. Because in my opinion, currently, that would be restrictive on development based on the additional assessment required without clearly displaying that there are effects from rail vibration. I don't believe that evidence has been provided of the actual and real effects of the rail vibration within the Wellington region.
so if you were looking to develop a property which is say 20 metres away from rail, and you suspect that vibration might be an issue, the mitigation measures for those property owners would be deeper foundations, or what are the available mechanisms to deal with vibration
There's
beyond the rail line itself?
There's actually some quite good examples in Styles. And Styles is evidence of examples of what you need to do, and the various costs that can be involved. But it's to the point of it could be as simple as just making sure that you're on, a certain type of slab construction, or the mass of your building is appropriate. I have done similar assessments and mitigation assessments in Canada, which is different from New Zealand in these aspects because we don't have seismic issues. The far end of things is basically base isolating the building, which is looking at around 6-figure marks.
So in terms of Mr. Styles' evidence in the examples, you agree that that's a representation
I
of the
agree
situation?
with Styles' evidence. On the light side of things, if you were worried about vibration, you could easily go and engage an acoustic consultant who has experience in vibration to measure the effects of rail vibration at site. And I believe Mr. has presented evidence of he deems as a rough figure for that sort of assessment, which is in about the ballpark of what I expect. But there, as we all are saying, there is quite a limitation on the amount of consultants who have that experience.
Mr. Hunt, in your rebuttal or your reply, evidence you have a very useful graph, figure 1, that I would appreciate you just leading me through it, just so I have a full understanding of what it's saying. Before you do that, what is this empirical data that's been used from some source?
Pull that up and I'll.
Okay, it's on page 7. Oops.
Yeah, so empirical data, so outdoor aircraft LD in the bottom axis is just runs through the range out from the 60 through to the closest house at 2. The top orange line is what the airport would consider to be the acceptable indoor standard if the LD 40 indoors was complied with at each.
So why is it static across all the noise?
Because they request the requirement to be indoor LD 40 across the whole area.
Right.
And that's the design standard.
And no matter how noisy it is on the outside environment,
Yeah,
it will
should
always
always
be
be 40 inside. So that means actually doing, particularly now that we've added the outer air noise overlay, there's my understanding, and mainly to be confirmed with the wild experts, but they're saying you really don't have to do much because it's almost a typical dwelling will reduce by 20 with windows closed. So it's really just a ventilation issue out in the outer air noise, and its acoustic treatment is only really needed in the inner noise overlay. But that aside, so that's the sort of de facto current approach.
Right. It just seems a bit counterintuitive to that the noisier it is outside, you still get the same noise level inside.
Yes, so that's different. So what I've been plotting there is the indoor DBA aircraft noise S4 and S5. So that's the yellow bars, and just doing some calculations on the outdoor minus the insulation of the building will deliver, and that's the dotted line. So I've just done an average across there. So that's just an average. And the blue line is something slightly different. That's the amount of reduction required, and that's really more in relation to the orange line at the top. So the reduction requires only 20 out at the 60 because you get 40 that way, and then the reduction is about 32 at the most exposed, and you will achieve 40 indoors. I think this diagram was has two functions, really to show that the indoor environment under S4 and S5 will be better. So we're talking, looking at that dotted line compared to the orange line. It'll always be better than 36 and indeed 30 in the outer area, the least exposed property. So these are better standards for the health and well-being indoors. And I guess it's also trying to show that even though the reduction is sort of stepped at that between the inner and the outer air noise overlays, that the actual, if you graph out the average, it is a sort of a continuum across the whole noise exposed area. And that's the dotted line. But in any way, it would deliver indoors 32, and then the most exposed 36 indoors across the noise exposed population, whereas the airport are satisfied with 40 indoors across the whole noise exposed population. That's just one comparison of the two. There are other factors that need to come into play, but that was the point there. it really does deliver a better outcome, and it's just a mix of the noise reductions required and how much noise is on the outside of the building and the resultant indoors.
Right. This is the source of the information to derive this.
Okay, so the aircraft noise contours showed me that the outer one was 60 and the inner one was 72. So that's just reading off the planning maps, really. The LDN 40, the orange line, that's the standard the airport is seeking. So that's, well, and it's actually the default position of the operative plan as well. So that's the source of that. The bars, the yellow and grey bars are, there's a slight sort of simplification here, because whereas we say the MTW plus CTR needs to be 30 or greater, obviously, well, it'll be 30, you know, so it's a bit of interpretation there, but worst case, you could say. And then for the 35, well, it's actually written as 35 or greater, and I've just said 35. So, so those are from the, well, the proposed plan is 4 S5 requirements. So there's really not a lot of sort of interpretation or sort of research or information. It's just reading the
diagrammatic kind of illustration.
Yeah, of the frameworks that we are dealing with. Yes.
This one question was about the defence temporary military activities. It's all dealt with in the section on temporary activities in the chapter in the plan. How does that tie in with the noise? Where is noise triggered, like this standard 6 in temporary activities?
Yeah, so the submission from NZDF submitted on the noise elements in Appendix 6, which has the noise standards for their temporary military activities. So we thought it best that we addressed those noise standards in our response. But yes, the decisions around temporary military activities should be for hearing stream 7, I believe. For temporary, I think it's hearing stream 7, which is temporary activities. But yeah, that we provided response on the noise components, the noise standards within those temporary activity standards for temporary military activities.
Yeah, so that's what I was looking for, the amended Appendix 6, and couldn't find it, but it was the same as the other amended table that
There's
been
still,
so amended that you didn't bother about
that hasn't been provided as yet, and there's still some items there that we have not accepted. I'm not sure if that'll be provided as part of the temporary. No. Yeah. I'm not sure. Sorry.
on the Appendix 6.
Yeah. In terms of a marked up one.
Yeah, it wasn't marked up.
Yeah, we didn't receive it was basically we got the submission from NZDF through their it would be their supplementary evidence. Yeah. Yeah.
Just to be clear, Commissioner, we've dealt with Appendix 4 and Appendix 5. The temporary military training activities is in Appendix 6, you're saying?
Yes.
Yeah.
Yeah.
But it was that one too. I couldn't. Do you know?
Yes, sorry, I was just going to say that it's probably going to be addressed in stream 7, just because there are nuances that are specific to temporary activities. So I think in terms of
you can deal with it.
So it's going to be dealt with then. Just, I mean, definitely need the noise input, but in terms of how it was structured, it came out of the temporary activity provisions. So if there's a nuance there that needs to be handled, I think in stream 7.
So the noise aspect will be dealt with there too.
Quite.
Yes.
There's a general agreement on the noise standards with defence.
There are some. There's I think only one outstanding item between us and Defence Force, which is to do with the distance setbacks for weapons and explosive firing. There are some items that we've left it up to, which are not related to noise, which are in around the noise standards, which are to do with the time of notification
Yep.
and the duration of activities,
Yeah,
which we've made sure to leave up to the temporary activities chapter.
Okay.
But we've provided advice on the appropriate standards if, the duration is increased, for example.
okay.
But we leave it up to,
Hearing stream 7 to deal with that.
yes,
Okay,
exactly.
thanks.
Yeah,
I just couldn't see how it was sort of wrapped up in.
yeah, I know, it was confusing for us as well. Yeah.
I've got a question for Mr. Ashby. In your rebuttal, paragraph 32, you said you disagree with another aspect of the noise P7 as proposed in Mr. Sullivan's evidence, which seeks to avoid the establishment of new noise sensitive activities throughout the air noise overlay and some other listed zones, which gets back to a question I had earlier around, in an ideal planning world, would you kind of try to prevent residential activities from setting up in the air noise overlay? And sorry, I'll just finish my thought. So there are some non-residential zones in the airport zone area. There's GIZ and there's mixed use, possibly. I don't know. I haven't got the overlay in front of me, but wouldn't it make kind of sense, I'm just thinking out loud, to sort of trying to prevent those areas from having, especially the mixed use areas, from having residential activities set up?
Well, in an ideal world, you might be talking about a theoretical airport with nothing but green fields around it. And yes, I think in that ideal world, you would seek to avoid any development within that high noise area.
I'm saying residential activity in non-residential zones, which is what Sullivan is speaking.
Sure. I'm not sure how a residential activity in a non-residential zone in terms of noise received, noise experienced by the residents differs from a dwelling in a residential zone. That's the effects on the people are the same, and the mitigation measures are the same as well.
I've turned the layer on to see noise overlay, and yes, there are some parts of it. But it was just a question I will ask her as well, because the mixed use, is it just some sort of residential component?
Yeah, and noise sensitive activities generally. I mean, for instance, like a daycare centre established in a mixed use zone for the children of workers.
Mm.
Similar kind of thoughts about that.
Okay. Because I will be asking her those questions too. Thank you. This is another question. I think you make mention, yes, paragraph 52. This is about the issue of whether the airport should be recognised as an affected party for consent applications within the inner air noise overlay. And you said if it did that, then you'd recommend the same approach apply for all other operators of regionally significant infrastructure according to the same status. So you're just saying that you're saying to us that if we agreed with that principle of them being affected party, then it should be more broadly extended across all high noise areas?
No, not across all high noise areas blanket, but in relation to providers of regionally significant infrastructure.
Within high noise areas?
Within high noise areas.
What to you? Any further questions?
Thank you very much. I don't know if it's too early, but the question around expert conferencing, did you have an opportunity to talk about that?
Yes, we have had a discussion about that. Look, obviously, good things can be achieved through expert conferencing. We think that what it would really require is strong directions from the panel about what it was you wanted conferencing on, rather than just go away and conference. And we say that because some of the positions are quite diverse, and I think you would need to identify the particular issues that you wanted either resolved or additional feedback on, rather than just a general go away and look at standard yes whatever.
Okay, thank you. I think we have considered the whole issue around insulation standards. We've just been talking about the inner DBA versus the standardized differential kind of approach. That was what drove that question in the first place. But we'll take your point, and we will ask this question to the other submitters, and come to a conclusion probably a bit later at the hearing.
Could I just interrupt there?
Yep.
I don't think it's enough to just to say set the experts off to discuss these. It's got to be aspects of those insulation standards, particular components, whether it's what's best for council or implementation checking, what's best for a party that has to implement the standard. Perhaps its relationship with the Quiet Homes program. Just sort of, if we just sit down and discuss the standard, we're going to be miles apart, and we'll go around. Thank you.
Further questions?
Just on that point, I think, although as much as I agree with you, I think getting too detailed into what it is we want the specifics about may limit the ability to come up with some sort of resolution that you can both live with. So I think it's a balancing act between the two things, Mr. Chair. And at the end of the day, it's just, regardless of what it looks like, if there can be an agreement on any facets of what this can look like in the plan context, I think would be a useful outcome of the process, recognising the challenges of current perspectives.
Very much for your attendance. Some of our questions.
Just before we close off, Noise, I have an update to the answer I gave you about section 16. You can't prosecute for section 16. The prosecution provision only refers to sections 9 to 15, but you can issue an abatement notice and then prosecute for breach of the abatement notice. So that would provide an avenue if the duplication caused you difficulties. The council could start with an abatement notice, and then if that's breached, prosecute a party for that.
Okay. Three Waters. So yeah. Yeah.
Apologies. Yes, I didn't think the amount of changes I made warranted one. There was one change, so.
Okay. Thank you, Ms. Cook. We have read your evidence and rebuttal evidence. And do we have Mr. Norman with us? Okay, good.
Yes, I'm
We
live.
can't see anything. Oh, now we can. There it is. Hi. Okay. Well, we'll follow the usual format, and that is give you an opportunity just to talk to your report and rebuttal. And so, Mr. Norman, if there's any key points you'd like to make, particularly if there's been any changes in view or recommendations recently.
Yes, I do have kind of an introductory statement just to give a broader outline of the history of the topic and where we've got to now, if that's okay to start with.
That's fine.
Excellent.
Yeah, warm us up.
Just to give a background about myself, my name is Maggie Cook and I'm a Senior Planning Advisor and the lead chapter for the Three Waters topic. I currently hold a Bachelor of Environmental Planning with a specialised major in freshwater science, and in previous roles I worked as the subject matter expert for water consents at Environment Canterbury. Three Waters refers to the assets and network services that provide safe drinking water, protect communities and the environment from hazardous effects of wastewater, reduce disruptions to our lives from wet water events, and convey urban stormwater in the environment. Well-functioning urban Three Waters infrastructure is crucial to the health and well-being for Wellingtonians and the health and well-being of our water bodies, and the supporting of the continued and residential and business growth and development of the city. A significant portion of Wellington's Three Waters infrastructure was constructed as a part of the city's growth and development post-World War II, and will require significant replacement over the next 30 years. Some piped infrastructure is estimated to be over 100 years old and will require more immediate attention. Since the installation of much of the Three Waters infrastructure, the city has grown and densified, and the demand for new development on Three Waters infrastructure has increased significantly. The upgrading of the Three Waters infrastructure has not kept up with the demand and the levels of service for the Three Waters network, which has continued to reduce. Additionally, the operative district plan is light on provisions for Three Waters infrastructure, particularly stormwater management, which is mainly attributed to the plan's age, which is over 20 years old. And it's mostly dealt with through subdivision rather than land use. The National Policy Statement for Freshwater Management was originally introduced in 2014 and was replaced in 2020. The 2020 version introduced the concept of Te Mana o Te Wai. Te Mana o Te Wai is a hierarchical framework which prioritises the health and well-being of the water bodies first, then the essential needs of people, followed by other uses. Clause 3.53 of the Freshwater National Policy Statement places obligation on local authorities, both regional councils and territorial authorities, to take an integrated management approach to the effects of land use and development on freshwater. Specifically, Clause 3.54 requires territorial authorities to include objectives, policies and methods in the district plan to promote positive effects and avoid, remedy and mitigate adverse effects, including cumulative effects, of urban development on the health and well-being of water bodies, freshwater ecosystems and receiving environments. The Three Waters chapter seeks to implement this integrated management approach through the district plan. It also seeks to implement the relevant parts of the Whaitoa implementation program, which is a process directed by the National Policy Statement and describes the community's aspirations for freshwater and helps set a platform for the collective measures to improve the health of the waterways. The Three Waters chapter has aimed to balance these requirements with the directives of the National Policy Statement for Urban Development to appropriately service communities with Three Waters networks and ensure a sufficient development capacity. While there are Three Waters issues for all matters of Three Waters. The key concern is stormwater management, with infrastructure capacity and stormwater overflows being a key concern that is manageable through the district plan. While drinking water and wastewater present their own limitations, issues with drinking water are more appropriately managed through the upgrade of infrastructure as to manage the 40% of drinking water lost through leaks. And on-site wastewater management is a Section 15 matter of a discharging of a contaminant. Therefore, as the rural framework acts in an integrated manner to achieve functioning Three Water management holistically. The Three Waters chapter sits alongside other methods to manage the demand on Three Waters networks, such as renewal or replacement of Three Waters networks funded through rates and development contributions, along with information, guidance and incentives to reduce demand and encourage more efficient uses of water, investigating fixing leaks, investigating water meters for residential use. The scale of Three Waters infrastructure investment required to respond to the higher environmental requirements and to support growth will be significant, and we need to be addressed by sustained investment delivered through the council's long-term plan. Nationally, regionally and locally, the management and objectives of Three Waters infrastructure are changing to have a much greater emphasis on reducing environmental impacts and improving water quality by increasing water sensitive design and hydraulic neutrality, which, in addition to ensuring environmental improvements, will also help cater to the population growth and future climate pressures. Achieving this change will require significant investment and adaptation away from traditional investment infrastructure approaches and ad hoc planning approaches. The intent is to cause a shift in best practice for the consenting process, with a greater emphasis on working collaboratively with developers, with council and Wellington Water in the pre-application process. I also note I have expert evidence from provided by Nadia Nietzsche from Wellington Water. Unfortunately, she cannot be here today, but any questions that are appropriate for her to address will be answered in the right reply.
So there's no, just to kickstart questions, there's no change to the objectives for Three Waters being recommended, is it correct? Right.
I believe in my supplementary evidence there was changing to the wording for hydraulic neutrality. It was suggested by Ms. Carter, looking at there was a difference between the policy and the objective, and it was amended.
Yeah.
If you would like to look at paragraph 18.
Can I just say that this recommendation is a fairly significant shift in policy, well, ultimately policy and rules, because as it read, it said there's no increase in off-site water peak volumes. So this relates to a number of the submissions that we will hear on this topic around developed and undeveloped states and all that good stuff. There will be some more questions on this, no doubt, but what is the basic recommendation? Why have you recommended not having that reference to no increase in stormwater runoff? Because it's a big change from saying there shouldn't be any increase in stormwater runoff from development to saying off-site water peak volumes are reduced below peak flows and things. And I'm just wanting to understand what the reasoning, why that big shift in paradigm almost.
For me, the original writing was unclear and it wasn't as directive as the policy was. While it says no increase in off-site stormwater peaks and flows, it didn't say anything from a basis of which it was just no increase in peak flows. There is a certain amount of assumptions that could be made around that wording, which is, and with policy 5 is a bit more directive, and it does close that loophole in a way of with it specifically from an undeveloped state. But I considered that it wasn't as clear as it could be.
Well, to be fair, I don't think it's a clarity issue. It's actually like a change in the whole sort of direction of stormwater management. As it was notified, it was saying no increase in off-site stormwater flow from development. This is saying that stormwater development must reduce stormwater flows, as I read it. So that's quite a shift rather than necessarily clarification, unless that was in the intention of 03 as notified.
So for context about when I came into this process, I came on the notification. So I cannot speak to the writing of that, but I can consider it a bit more. My thought was if it says no increase in stormwater peak flows, it just, without any kind of guidance, like you said, with the some of the submission points that we are going to deal with, it's that could be argued either way, and that's the that loop I'm trying to close with the changing wording, but I can go and consider it further.
I think you're talking past each other a little bit. The question, as I understand it, is if you look at 03 by itself, it does change the paradigm. It goes from a no increase to a reduction. But as I understand Ms. Cook's reasoning, there is a disconnect between what 03 was asking for and what P5 was then implementing from 03. P5 as drafted required a reduction. So what she's done by changing 03 is to make them more consistent so that P5 is giving effect to the new 03. So it's not that the plan's direction was not to require a reduction. So it's not a fundamental paradigm shift in the way that the plan or what the plan asks for, though it looks like that if you just look at 03 in a vacuum.
Sorry, do you want to, isn't that, I think it comes down to the undeveloped state that we're talking about as well. So it's quite that's the shift, seems like a shift. So putting that 03 aside and understand that, but the shift that you have to, which Stratum bring up in their submission, that you have to take account, you don't take the existing environment as if it doesn't include the building that's already on it, that you in fact have to deal with all stormwater. You have to have hydraulic neutrality across the site, not that existing building stays as it is and then you don't increase that. So that's quite a shift, isn't it? That's quite tough.
It's a shift from what is currently in the operative district plan. I would agree with that, but because it is a largely silent matter. The intention behind there being a shift to this higher standard comes in conjunction with the national policy statement for freshwater management requiring us to have positive effects, and as well as maintaining, avoiding and mitigating the adverse effects of urban development. The intention there was that if we are just considering the existing environment, that is essentially we are maintaining what is there rather than requiring positive effects. And the concern there is that you're almost kicking the proverbial can down the road in a way, because we already have not only issues with our receiving environment, with the health of our water bodies, but also with our infrastructure.
So that puts it back to the landowner, but they then have to improve their current situation.
Yes, the intention, I believe, is set out in the Section 32 report is for it to be more of a user's pay of development, and the intention is that the way the system has currently been run is developers have fully had to manage the effects of their development on Three Waters infrastructure, and we are now internalising that by requiring higher on-site management.
Does the question of existing use rights come up?
Existing use rights or existing environment rights? Sorry.
They've got an existing situation, haven't they, an existing environment. Is it just thinking about their rights, or what the right they have is an existing situation to continue in that way?
That may be something that I'd have to go and have a think a little bit more about, but I don't think so, because we're only talking about a situation where someone wants to undertake a new development or undertake a renovation, they want to change their use. So if they're not making a change, no one's suggesting that people have to come in and provide something that they're not providing. It's only if they want to undertake some further development that they may have to undertake more stormwater management than is affected by the change they want to make. They might have to make a greater change to otherwise better internalise the effects that they are already having. But I don't see that as engaging existing use rights, but might have to think about that in a bit more detail. That's my sort of
definition of existing environment.
So that's another matter I was going to address you on later. I don't know whether you want to continue with Ms. Cook or, but I don't agree with the Argosy parties about with their argument that when you're in a consenting process and you compare to the existing environment, that what this policy and objective does is somehow undermine that. I don't agree, and we can go through that, but that's my so that's my reasoning why it doesn't affect existing use rights. That's something that is my sort of response on the spot rather than something I've actively considered, but it feels right. But I can go away and just have a look at some of the case law on existing use rights a bit more if that would help.
Yeah, so certainly when I was reading this material, there was the one term just flashed out at me in terms of the undeveloped state, particularly with the changes that you're proposing in terms of Objective 3. So you've got a situation, you talk about the central area here. So basically all the way down through, it's all developed. So therefore the change in approach would be that a landowner would have to provide for hydro-neutrality, not against what is there at the moment in terms of what they have, but in terms of an area which has been grassed. So in terms of Argosy and certainly Stratum as well, we're effectively opposed to this. Wouldn't this actually provide a significant disincentive to various other motion of density within central area cities by having what is potentially quite onerous investment required to deal with an existing situation?
I think in relation to the incentives around or disincentives for someone developing in the city centre, was that I think Mr. Norman would probably, in his evidence, and would be able to speak probably a bit more appropriately to those questions. My understanding of his evidence is that this is incorporated into the land costs and not an additional cost on the development. But again, he can probably speak better to that than I can.
Yeah.
Would you like me to step in now or wait until later? That's your preference.
I just don't know if this is a matter of just pure development economics. Yeah. It's the starting point which is being proposed, is that you're looking at a site in its undeveloped state. Wellington City is highly urbanised compared to a lot of districts. So surely you've got to take into account the existing situation, which is there, which is a developed state, as your starting point, rather than saying Central City Zone and Tiaro doesn't exist, it's all a grassed area, and we'll take that as starting point in terms of stormwater neutrality, hydraulic neutrality. So we've got evidence to the contrary, saying that is unfair and unreasonable to actually do that. So I'm trying to get within my mind how you can justify the quantum shift from the existing that there is, with talking about a site in an undeveloped state where in reality it's not there, it is a developed state.
Yes, it is a shift. And this was considered as a part of the development of this definition of undeveloped state. We had these discussions with both Greater Wellington and Wellington Water, and looking at the state of our urban environment, but also taking into consideration the state of our receiving environments and the state of our Three Waters infrastructure. It is a definition that is utilised for this modelling, and looking at the evidence provided by Stratum, I think particularly Mr. Stewart, with the Oricon report, I think it does, it demonstrates that there is that the usage for this term for the modelling is actually quite a simple process. And then that modelling is then used for a solution to get this hydraulic neutrality. So it's kind of for an urban zone that might be a detention tank, which Mr. Stewart discusses, or it might be an alternative solution to that. But it's the definition was, we looked at not only whether we could consider it in a modelled to be the impermeable state, looking at also whether it was a forested state or these other terms, and we came to the conclusion with Greater Wellington and Wellington Water for it to be grassed. And the reason why it uses urban open zone and pastoral is because those are modelling terminologies that they're then used to demonstrate what level of solution is needed to achieve hydraulic neutrality. And so not considering the current state for this modelling is to achieve Te Mana o Te Wai, considering the receiving and also the infrastructure issues that we currently have.
Yeah, no, I think that's well understood in terms of the receiving environment and the fact that probably there's been a historical lack of investment in stormwater infrastructure. So there's a catch up to be done. Whether that should be in terms of a resource consent process, whether that should be all loaded onto somebody who they want to do is to demolish the existing building and put another building up there, so they're automatically on the back foot by having to put in potentially costly solutions to that. I guess my initial concern is it equitable to actually do that when on one hand the council is actively trying to promote intensification and urban development, on the other hand they want to potentially restrict it.
Yeah, I agree. It is a difficult balancing act. I think in terms of it being equitable, it's a difficult one for me to answer, because it's where you draw the line in the sand of this is, as you said, has been a historical issue, but if it is not addressed, will it then continue to become an issue? And as Mr. Norman's evidence addresses, is not only its development contributions not adequate, but then the cost to increase the infrastructure to the level that is required. is hundreds of millions of dollars on ratepayers. And again, he would be able to elaborate on some of those questions around there. But requiring on-site stormwater management to continue for the development is, as you said, it's a historical issue that we've had to draw a line in the sand somewhere.
Maybe, Mr. Norman, you could chip in here. Your
Yeah.
response.
Thank you. Very briefly, just by way of introduction, so I'm Chief Economist at GHD for Australia and New Zealand, was Chief Economist at Auckland Council, so have been on the council side of the fence in terms of these processes, and have, in the course of my work, been required to review a lot of other people's economic evidence and so on for these sorts of processes. But I'll just jump straight into the immediate issue that we're discussing around the fact that effectively we're, the policy being proposed would require developers who purchase an existing property that has an existing footprint on it to not only meet the hydraulic neutrality needs of any additional footprint that they might cover, but also chip away at what the existing footprint. That's obviously the contention here. My argument on that point would be, following on from Ms. Cook's comments earlier, we have an existing underinvestment in infrastructure. Those sites with their current footprint are already contributing to the stormwater challenges we have, because historically the contribution from those sites has not been sufficient to meet the stormwater needs, and that's pretty evident every time we have a major rain event. So your options are quite limited in terms of what you can do. Yes, new growth, expansion should absolutely, in terms of footprint, so whether that's greenfield or brownfield, I think we can probably agree on that one quite easily. It should pay the full cost of that additional impact on the network. So that's easy. In terms of what you do with existing brownfield areas where you've got development, you effectively have those two choices. You have the option either of massively increasing rates and therefore trying to spread that cost across all development and coming up with centralized solutions for dealing with stormwater runoff. Work previously done by Wellington City demonstrates that those centralized solutions are eye-wateringly expensive, and that would have to be reflected in rates. So that's your one option. Your alternative is the one that's being proposed here. At the time of redevelopment, we're asking those undertaking the redevelopment to improve the way that stormwater is managed from that site, acknowledging the fact that the existing footprint is already contributing to the problem that we have. Yes, undeniably for developers who have already purchased land on the assumption that they wouldn't have to deal with the existing impacts on stormwater of that land, some of them will have overpaid on that basis. But as Ms. Cook's pointed out, the alternative is that we kick the can down the road and that the problem continues to be perpetuated indefinitely. One advantage of taking an approach where we're very clear about this expectation now is, while it will affect those who may have overpaid, is that you send a very clear signal to the market along the lines of user pays principle, economics 101. Those who are, sites that are generating the impact are the sites that need to account for those impacts. And so it stops us from perpetuating the cycle. What will happen over time is, of course, that raw land prices will fall. We won't put up the price of housing, we won't put up the price of commercial development, the land value falls. That is bad news for those who may have overpaid on the expectation of not having to provide for the existing impact of their property. But the alternative, so that would be a paper reduction in value of land. The alternative is a real cash flow increase in costs if you spread it across all ratepayers, whether they intend to redevelop or not. And clearly the expectation of a redevelopment is because a developer believes they can extract more value from that piece of land. So they're probably more likely to be able to accommodate that that change over time than, you know, Mr. and Mrs. Smith living in their house with no intent of redeveloping that property. But the signal will pass very clearly and quickly into land values, which is exactly where the cost should sit, because it's effectively the cost of infrastructure to accommodate the negative impacts of that property.
Just a question, or a couple of questions actually. You're saying would otherwise the other option is a massive increase in rates, but wouldn't this policy only chip away slightly at the issue and leave the majority of the issue outstanding and yet to be resolved?
Yeah, so it would be a more piece by piece solution. Again, I'm happy for Ms. You know, that's not necessarily my area, so Ms. Cook, please jump in. But yes, of course, it would be piecemeal rather than a centralized solution. But having looked at the costs associated with a centralized approach, which you may have seen my earlier piece of work as well, you know, if we just put that price, say, on greenfield development, that cost, you'd be looking at $70,000 to $120,000 per dwelling just to cover stormwater. It wouldn't be reasonable to put that just on new developments. So if you looked at new developments' share of the total across the next 30 to 50 years, there'll be about a third of all dwellings. So you'd be putting 2/3 of that cost on each property. So you're looking at sort of $60,000 to $80,000 in costs that would need to be lumped onto individual properties. So Ms. Cook's probably better to talk about the implications in terms of the NPS as the specialist on that, which I'm not. But what it demonstrates to me is that this allows you to get an improvement, but while doing it in a way that signals clearly to the market, and also that allows flexibility. The developer of that land can come up with the best solution that works on that land as efficiently as they can, rather than requiring a centralized approach. You have to do it this way, and we're going to build this thing over here to offset that cost, that impact at huge cost.
In terms of solutions, what realistically are the solutions for a developer of a brownfield site? If the space is limited in terms of water sensitive design, and I accept the relationship there, if the space is very limited for applying those principles, what are the solution options for a developer to meet the principles behind this policy?
Ms. Cook, that's probably a question for you. I know retention tanks have been mentioned already in some of the examples that we looked at in the previous work that I did on this topic for Wellington City. You know, we priced up the impacts of a rainwater garden or swale and the likes. I appreciate that in a city centre site that has very high site coverage already, those become challenging options, and perhaps something like a retention tank makes a bit more sense. But Maggie, I don't know if you have anything to add.
Yes, so as briefly mentioned, particularly for hydraulic neutrality, detention tanks is the solution that is often referred to, particularly in the reference for design storm hydrology that Wellington Water puts out for the 1 to 3 residential units. There is a set approved solutions for people to install a detention tank, and for the 4+ residential, this also works with the water sensitive urban design, and there is the range of options, which is going to be a case by case looking at what are the potential solutions for the site, and site constraints are acknowledged in that framework. There is solutions such as mentioned detention tanks, retention tanks, bio gardens, green roofing, constructed wetlands, permeable pavements. It's multifaceted solutions to get achieve hydraulic neutrality and water sensitive urban design.
Would it be a stretch in saying that without these particular recommended provisions, it would be hard to give effect to the Te Manawa Te Wai direction?
Yes, and also in response to the question previously about it's been chipping away at the problem at whole. I believe that was the question, is that this is not only a part of a broader plan for Three Waters. As I believe I indicated in my introduction, it's quite a multifaceted, it's a big issue. We have a massive Three Waters issue in Wellington, and it is a portion to get the solution, and in order to not just maintain, but that promotion of positive effects, and to try and manage not only water quality, but water quantity on site, as that is difficult to achieve off site.
Do development contributions have a role to play in this at all? I mean, what was the work done around that side of things for this?
Development contributions were looked at, and particularly Mr. Norman did a lot of work in that space. It was definitely determined that what we have as our development contributions is not going to get the desired outcomes currently set. I believe Mr. Norman can speak more to this, but they are quite low and not probably as implemented. Well, probably with the policy, it's the difficulty is that being the long-term plan process, and that will need to be updated and implemented through that process. And it is a collaboration between the two processes to get those better outcomes.
Would you like me to comment here, or happy to? DCs, so again, putting my ex-council hat on, constant challenge for councils to get the pricing right. And many councils charge way too little in terms of the true cost of delivering infrastructure. So yes, absolutely. My view is getting DC pricing right would need to be part of the solution. But I'd go back to my comment earlier that we already have 2/3 of the dwellings in Wellington that we're going to have in 50 years' time. And additional to that, given the desire for intensification, which is part of what's prompting this discussion, the fact that we aren't necessarily increasing the area that's covered by 50%. DCs will play their role, but they certainly won't resolve the problem. We absolutely need to get them right for greenfield development and to make sure that we're accounting for those impacts properly. But we've got an existing problem with the existing urban footprint.
Just excuse us for a minute, Mr. Norman. That's it. Good. Slight technical glitch here, but it's all resolved. Okay. Questions?
So permeable surface is one way of delivering. It's one tool, isn't it? But there's a specific requirement for a permeable surface in all zones, except for the two large rural residential ones. How's that delivered in a 100% coverage bulk mass of a city centre built site? Is that still that's required? Or could they use another method?
Yes, so I believe this is outlined in my section 42A report. I cannot remember the provision off the top of my head.
Service is about your paragraph 76.
Yes, so there is a specific rule framework for 1 to 3 residential units for permeable surfaces. So those are for the MDRS rules. But intentionally, a rule framework was not developed for permeable surfaces for 4+ or non-residential, because that is an issue when you're considering the city centre zone or an area where there is intentionally going to be high permeable surfaces. Apologies if I get permeable and impermeable mix. I think I meant impermeable. And so this is why considering it, also having meetings with the consenting team to look at the implementation of things, it was I thought the most appropriate place to look at permeable surfaces for 4+ residential is in the matters of discretion for the water sensitive urban design. Yep. And so that is where it sits. There's no minimum requirement of permeable surfaces for 4+ residential units.
So The question is how, it's one tool, is what I was saying, but it's got a specific requirement in relation to that. How do you envisage that? I don't see how that gets delivered in a fully built central city site. I mean, there aren't any surfaces apart from the roof, so I suppose that's a roof garden.
I think that's the point. I think what, as I understood Ms. Cook's answer, she was saying that in the central city, the permeable surfacing has been added as a matter for discretion for assessment, not as a rule. There's no, there's no standard where you have to provide 20, 30, whatever it is, % permeable surfacing. So it may well be that a developer comes along and is able to say, look, the maximum feasible area of permeable surfacing is 0, or I'm adding a grassed area on the top which will filter down through guttering or whatever, and maybe that's able to be taken into account.
I get it.
So it's something that's aimed for, but not necessarily a hard and fast requirement.
Okay, thank you.
Can I just ask what level of road testing of these provisions is being talked about? You've had discussions with the consent team in terms of the practicality and workability of it. But, you know, historically, in the last few years, and having had some involvement with the development as well, there has been a reasonable amount of criticism in terms of being able to get a straight answer to a straight question about what do we need to do here, and that observation is reflected, if you like, in certainly Mr. Stewart from Stratum's even, because it is quite a significant change, which is, well, a very significant change, and I just wondered, in terms of, has somebody sat down with a theoretical 20-lot subdivision in Johnsonville and worked out, you know, what the pros and cons of implementing this will be? Has there been some sort of assessment on additional cost per unit? And I know Mr. Norman's cost, you know, referred to some of that, and also talk with the people who are actually delivering intensification, which is required in other parts of the plan. So, you got any perspectives on that?
From my understanding, during consultation and prior to notification, there were discussions with the development communities. I can't go into what depth was in. Fortunately, I was not there. In terms of the road testing, this is something we have gone over and over again, considering the policies. It's because Wellington has such a unique urban form of a wide range of types of developments and issues that we're going to run into. We have considered, you know, scenarios, but it's such a case-by-case situation. And yes, I understand, as previously as a consent planner, getting a straight answer is a lot more difficult than it used to be. And that is possibly because we are dealing with a lot more complex issues than we used to be. But this is where really emphasising the need for coming in during the pre-application process, and particularly with Wellington Water and the council, and looking at all the options for the site and integrating it into the plan for the development.
That was going to be my next question. I think, and I read it before, I think it was in your rebuttal, that there seems to be an element of pre-application, good pre-application advice with Wellington Water and with council will actually solve a lot of issues, but it doesn't give a whole lot of direction to decision makers about what if they don't provide what are the circumstances in which a consent would be declined, for example, but not providing for hydraulic neutrality. And the other thing, and just in response to your previous comments about the consent team, but I understood that these 3 waters provisions were introduced in between the draft and the proposed plan. I don't think they were in the draft. Can you confirm that? Or to the nature that they are at the moment?
The answer off the top of my head without taking too long, and I will get back to you on this.
Yeah, no, it's not a biggie. I remember looking at the draft and the chapter. Could well be wrong. That was my understanding. So the reason for that question was going back to the road testing. Who's somebody from the consenting team actually had a look at it, and had there also been some collaboration or discussions with some of the big player developers in terms of practicality.
Because, again, off the top of my head, I believe there was a lot of modelling done within the spatial plan as well for Three Waters. So I think it has been a matter that has been considered throughout this plan review. The degree of change, yeah, again, I'll get back to you on that one if that's okay. Thank you.
At the risk of standing in between everybody and lunch, I'll try and make this brief. If I can turn it on its head a little bit. So in the report, you've shared the same comments that were shared by the report writer in stream 1 around PC1, the plan change 1 provisions of the RPS, basically stating that because they don't have any legal effect at the moment, they're not things that we can take into account. There's a whole lot of ideas that have been, to use Commissioner Daish's analogy, have been road tested. There's experts, there's communities, there's fly tours, there's a whole lot of things that inform the development of that. And all of those good ideas have been put into a kite that we've called Plan Change 1. The concern I have is that by saying no, Plan Change 1 doesn't have any weight, runs the risk of ignoring all of the well-founded things that have come out of that process that sit within that kite. Is there a risk that we miss? So if we didn't say it was part of Plan Change 1, let's just say there was a whole lot of things they worked on and they come up with some provisions that had evidence based on all of the stuff I talked about earlier, would we not look at them in respect of the contribution that they can make to the planning outcome? Because the concern I have is by putting them all into a Plan Change 1 kite, we kind of take that as an opportunity to go, well, there's no weight in that. Am I asking the question? It's kind of a little bit backward, because some of the things that I saw in Greater Wellington's submission, I felt actually warranted further consideration, but they were things that we looked at as being Plan Change 1 things that couldn't, or matters, sorry, not things, that we couldn't take or have regard to, like the report writer on 1. Do you have a view on how they would be treated differently if they weren't in that Plan Change 1 kite? That's a bit of a loaded question.
I think particularly the, as I said, the FITOA program, we did that was considered as a part of our section, so the development of these policies, and that's outlined in the Section 32 report. I think because a lot of these issues that was dealt with in Plan Change 1 comes from the National Policy Statement as well. It's a tricky interconnected issue where I have Greater Wellington has made specific submission points that are related to Plan Change 1, and I have considered them both in relation to them in Plan Change 1 and as a standalone submission, with more emphasis on considering them as a standalone submission, as well as yes, considering all of the community outcomes that was intended through things like the National Policy Statement and the FITOA program.
Cool. Because the other, the overarching concern that I have is that the changes that we made to the introduction around the hierarchy of considerations that Te Mana o Te Wai has by looking at the the water first and things like that, then that leads the reader of the plan to a place where when they carry on, they are going to see policies and objectives that actually give effect to that hierarchy of looking at the water bodies first. I'm just, my question is, have the changes to the rest of the plan alongside those changes in the introduction allowed us to do that? In other words, we didn't just change the introduction to introduce a hierarchy and then change nothing else. Or did we? I don't know.
I would like to think that they flow on, particularly looking at, for instance, objective 1, which is protecting water bodies and freshwater ecosystems, and with water sensitive urban design, and continuing with trying to get to Manawatū throughout it, as well as balancing the requirements for us as a council to be managing through water infrastructure.
So the provisions there are just further strengthening that introductory text. The other question I have is when I look at the new definitions around wetlands, about natural wetlands, construction, are they what's the definition in the introduction to Manawatū? Ecosystem, fresh, are they covered by that? Because we've added in the well-being of water bodies and freshwater ecosystems in the introduction. Are those wetlands part of those freshwater ecosystems?
My answer comes in 2 parts for that one. So the wording for the freshwater ecosystems specifically comes from our requirements under 3.54 for the NPSFM. So just making sure that's emphasised in there. With wetlands and specifically adding in those definitions, that's also linked to what we are requiring for water sensitive urban design. And one of ththose options is constructed wetlands. And the reason why those definitions were added in is to ensure the developers that they do not, if they construct a wetland, they are not going to trigger the national environmental standards of freshwater management, which have quite robust and have quite high levels of requirements around what activities can and can't occur around a natural inland wetland, which has its own definition, and adding the 2 in there is to try and make sure that
Cool. Yeah.
that is clear. In terms of
just to interrupt there. So the when we talk about the health and the well-being of, and you've added in bodies and freshwater ecosystems must be prioritised first. That priority first applies to all of those, the constructed, the natural, all of those wetland definitions that have now been introduced. It's applicable to them, or not. Because the concern I have is that I don't necessarily disagree with it, but the concern I have is if you add in freshwater bodies and ecosystems must be prioritised first, then can someone look at a constructed wetland and go, that fits that? Or is there, or am I missing the boat a little bit here? Because I looked at the additional definitions that you put in about wetlands and inland wetlands, and then that addition in the introduction. Do those things hold hands in a natural way, or is there going to be some conflict there potentially? I don't know. It's just a question.
I didn't consider there to be a conflict, but I can consider it further. For the ecosystems, it's constructed wetlands do have their own unique ecosystems, but they have a unique function of also specifically when you're talking about water sensitive urban design and urban landscape, provide a function of filtration and management. I was more
thinking about water bodies.
Yes.
Because so the freshwater ecosystem is probably a little bit, but we've added in water bodies, and so it's just to make sure that there's no fish hook in there, excuse the pun, to say that now that we've added in there that you have to consider these things first, water bodies and freshwater ecosystems, whether we're not capturing unintendedly constructed wetlands as part of a water body.
Yeah, and I think this is somewhat dealt with in the NPS and the NES with that, having that really strong definition of a natural inland wetland and with the protections that are required around there.
Cool, thank you.
Can I just add a comment to that, which was to go back to your characterisation of the position on the proposed plan change 1. Because you have to take it into account. The council, it's not that it's irrelevant. You have to take it into account. It's a question of how much weight you put on it. I think that's consistent with what you were saying. But of course, that may change over time. And back in January, when in the first hearing stream, I think it had been notified, but and maybe submissions had come in, but no further submissions yet, and no timetable for hearings had been set. We're now the 42A reports for hearing stream 3, I think, were released yesterday. So that process is proceeding reasonably quickly, and it may well be that by the time you're factoring all your thinking together, a little bit more weight can be put on it. So I might take that back to the council and just see if we need to provide you some updated positions on that.
That's all. Questions? Okay, thank you very much for your time and presentation. That's been very helpful, and thank you, Mr. Norman, as well.
Thank you for having me.
With that, we'll adjourn the hearing for lunch and resume at 1:30. Thank you.
one submission to make on Three Waters, so
Okay,
up to you how you see.
No, I
If
think
you've still got questions for her, then.
we had finished
Great.
with questions,
Okay.
Ms Cook,
Okay.
so we're happy to hear from you now.
Okay,
That's all right. We will go? Yep.
I will try to, summarise or reflect in what I say, some of the discussion that we've had this morning, but the point that I wanted to discuss was the argument, as I understand it, from Argosy, I think it's Argosy and others, about the existing environment point, because as I understand what they're saying, the council's approach means that when you come to consider resource consent, the council would require a decision maker to adopt an artificial environment for that assessment. I don't agree. What the council has done is propose a permitted activity standard, which is intended to enable developers, if they can achieve it, to not need a resource consent to address this issue at all of hydraulic neutrality. So if they achieve that standard, there won't be any assessment against any existing or other environment under Section 104 because they don't need to get consent. It's a permitted activity standard. Now, permitted activity standards have to be measurable. And that's why the council has adopted this modelled state rather than no worse than existing environment or some other state, because it wants to promote positive effects on the environment, which it's required to do by clause 3.5 subclause 4 of the NPSFM. So this permitted activity standard is one of the main ways that in the plan the council is seeking to give effect to that requirement of promoting positive effects. If you don't meet that standard, you need a restricted discretionary resource consent, and the matter for assessment is the extent to which you comply with the Wellington water standards, the extent to which you have an effect on the environment, or the extent to which you improve the state. But if you make no changes other than to effectively be purely hydraulically neutral, in other words, you're not going to have any worse effect from your development, it's entirely plausible that you will get consent. If you're providing significant housing and other benefits, then that will all be considered in the mix of the restricted discretionary activity consent. It's not actually necessarily forcing developers to spend significant costs taking things back to a state that no longer exists or which is artificial compared to the outside environment. So I don't see a legal problem with it, and in fact, while there are no doubt other ways in which the council could have tried to promote positive effects as it's required to do under 3.54 of the NPSFM, this is the one that the council has proposed to do. You could quibble with whether the modelled state definition that the council has adopted is the appropriate one or should it be something different, but I don't see any legal problem with what it is. And in fact, it seems to me a rather clever way of providing for a permitted activity standard which is measurable, and as Ms Cook pointed out, what the Oricon evidence has done is in fact showed that it can be done, and done reasonably in a reasonably straightforward way. I don't mean that the what it would require is necessarily simple, but that the modelling, the actual consenting process that you would go through can be done, or not consenting process, the process to demonstrate that the permitted activity standard is met can be done. Now, there is the point you raised about existing use rights. I think the answer that I gave you is right, which is that nobody's suggesting that people who have an existing use right now will have to go and do something to give effect to this policy. It's only if they are going to undertake a new development, whether that's to expand an existing, go up in height or expand the footprint of their current development. And also then there's the permeable surface issue, which is there's an assessment criterion that's been added, but it's not a standard. It's not requiring people to provide a permeable surface where they currently might have 100% impermeable, for example. But if they can do that as part of their new water sensitive design, well, then that would be great. More generally, a lot of this, that like reverse sensitivity focuses on equity, and reading between the lines of the Section 32 report, which is, as Ms. Cook says, takes the position that existing regulation of this issue on the operative district plan is light. I think that's probably euphemistic, really. The position is that it was inadequately regulated, and it's no doubt a contributing factor, among other ones, as to why we have this significant infrastructure deficit. The council has, I don't know the number, a significant number of millions of dollars intended to be invested over the next 10 years in the 10-year plan to improve the infrastructure related to stormwater, replacing pipes and all of that sort of stuff. That's one solution to the issue. But what this plan tries to do is say that it's not the only solution to the issue, and those who develop have a role to play in seeking to reduce the existing impact that the current level of development has in producing stormwater runoff, which our pipes are inadequate at the moment to deal with. And all of that is really an integrated package. The Local Government Act and DCs, the role of the regional council in setting water standards and giving effect to Te Manawa Te Wai, the council's own obligations to give effect to Te Manawa Te Wai, and the way in which the district plan seeks to create these positive effects on the environment through the mechanism that the council's identified. So that's, I suppose, lays the field for what you need to be considering. The other part of that is to answer a question that was asked earlier. This is in some tension with, if not conflict with, the intensification directive of the MPSUD with Te Manawa Te Wai and the desire to have positive effects under 3.54. And there's probably two ways in which that is reflected in the plan. One is that Three Waters has not been identified as a qualifying matter. The council is not trying to restrict density or reduce the policy 3 or MDRS to reflect the existing infrastructure deficit, as other councils have done in New Zealand. And it has this permitted activity standard, and it's going to impose some costs on developers who do wish to develop, but it's not, that is the way that the council has sought to balance these two policies from separate national policy directions which are in tension. And the other, what's the other one?
Infrastructure.
Thought I had another reason why, how the plan gave effect to that conflict.
Old age, it's just old age.
Yeah. It may or may not come back to me. But the council doesn't shy away from the fact that these are in conflict, and you have to find the balance, the equitable balance, as to how the council gives effect to those. Now, as I say, it's not one which requires you to engage with section 77 to see whether this is an appropriate restriction on development, because it's not seeking to change the threshold levels of density, but it is therefore simply a section 32 analysis for you to assess the costs and benefits. Mr. Norman's evidence will hopefully be helpful in that. Other parties have produced evidence as to the effect that it will have on development. It's a very real concern if it would provide such a disincentive to development that the NPSUD will not really be given effect to. That's a significant concern if that's the view you reach. But because we are just talking about a permitted activity standard, and there is a, in my submission, credible consenting pathway nonetheless, I don't consider that to be the case.
Thank you. Any questions from the panel?
Just one quick one. So could the logic of that last comment also not work in reverse? So if you're creating something that in and of itself, because you're responding to the NPSFM, that the NPSUD becomes unworkable, could it not also be that you could propose things in the NPSUD implementation that make the Te Manawa Te Wai provisions unworkable? Is it not the same both ways?
It is.
Yeah. And that's what you're referring to with regards to that. Our task is to find that equitable balance.
That's right.
Between those things to make sure that we're giving effect to the intent of both.
That's right. So where they are in tension, if you give effect, if you enable such, if you don't provide the right consent triggers in the three waters space, and you just allow intensification to blossom, there is a risk that the council's plan won't be giving adequate effect to the NPSFM. By contrast, if you make it too difficult to intensify because of the requirements you impose to give effect to the NPSFM, then we may not get as much intensification as the NPSUD requires.
Does scale and magnitude play a big role in that equitable balance?
I could probably answer a portion of that. In terms of considering the scale and significance of the development itself, it's somewhat why we split it into the two sections that you can see. So 1 to 3 residential units and 4+. So one reason why it was to give effect to the NDRS, we do not consider infrastructure capacity for 1 to 3 residential units, but we can consider permeable surfaces and hydraulic neutrality because that is set out for stormwater management in section 80E of the RMA. But for those 4+ and non-residential, where the scale and significance, particularly in Wellington, for those variety of developments that could potentially occur, we have kind of considered a wide range of issues and can put it the matters of discretion on that level. So those scale and significant issues can be considered, and it's probably going to form a basis of the AEE, provided if a results consent is needed.
I think it's for me, it's a very useful context. I'm not sure it helps us in our decision making moving forward. But your the analogy that you have presented is very helpful. Yeah.
That's good. Look, I don't envy you at all. Giving effect to this national direction, the plan has been put together at pace. It's affected by other plans that have been put together at pace and are going through the same process. There's a different intensity to this plan development than other traditional Schedule 1 plans, which proceed at their own pace and usually with static information. Maybe there's an update halfway through that happens, but by and large it's able to be dealt with. we don't quite have the same flexibility to deal with new information as it comes in.
Thank you. Any more questions? Okay, thank you, Mr. Wellington.
Thank you.
That's good. The tabled statement here, is this, I note that it's called subdivision and earthworks. Is it intended to cover both?
Yes. So the tabled statement covers both, but yeah, it's a high level overview. I've got some other notes prepared that I can speak to for both earthworks and subdivision when we get to each of those topics.
Okay, well, the floor is yours just to sort of provide us with any updates or key points you wish to make.
Cool. So thank you, Chair, and good afternoon, Commissioners. Just to quickly introduce myself, my name is Hannah Van Haren Giles, and I'm a Senior Planning Advisor in the District Planning team. I'm the author of the Section 42A reports for both earthworks and subdivision, and I was also the reporting officer in the previous hearing stream for the General Industrial Zone, and am the reporting officer for the Port Zone, Quarry Zone, Hazardous Substances and Contaminated Land chapters. So you have my tabled statement with you. There are a few high-level scene-setting comments that I can read those through with you if that is of benefit.
Yes, please.
Okay. So these apply to both earthworks and subdivision. So the first point is to note that the interrelatedness of earthworks and subdivision provisions, particularly the subdivision chapter, that they're quite interconnected with provisions throughout the PDP. And that includes the noise, infrastructure, three waters and natural environment value chapters. So these topics are yet to be heard or are being heard during this hearing stream. Throughout my Section 42A reports, to the extent possible, I have assessed and made recommendations on earthworks and subdivision provisions, but I have also identified instances where a chapter to be heard in a later stream could have a material bearing on the recommendations in my Section 42A reports, particularly where they will likely need to be consequential changes to the earthworks and subdivision chapter arising from those amendments and the outcomes and direction of the parent chapters. Do you want me to continue or? Yeah. So the second point is, since the publication of my Section 42A report, the National Statement for Indigenous Biodiversity was gazetted and comes into force on the 4th of August. Clause 3.10 of the NPSIB directs local authorities to make or change their policy statements and plans to include objectives, policies and methods for managing adverse effects of SNAs on new subdivision use and development. And so Council is currently working on the next steps for implementing the NPSIB. The third point I wish to note is just to acknowledge the national planning standards, which establish where provisions on various topics are to be located. Of relevance is that the standards direct that provisions for subdivision be located within a subdivision chapter. And secondly, that the subdivision chapter cross-references to any relevant provisions under the infrastructure, energy and transport headings. This is particularly important because a number of submitters have sought to introduce infrastructure related provisions to the subdivision chapter when that would not align with the structure imposed by the standards. I've then prepared notes separately for earthworks and subdivision, so I believe we will continue with earthworks.
Yeah, if you could just do the earthworks.
Can I
No,
ask a
maybe.
quick question?
Certainly.
Just a quick question on your second point there. At the end, you say that the council's currently working on the next steps for the implementation of that. Well, what do you think that will mean for us, if anything?
At this stage, I probably can't make any comment on what that would mean for you guys.
Okay, it's just something for us to be aware of, right?
Something to be aware of, that it comes into force on the 4th of August, but council as a whole, our team will look at that.
Yeah.
While we've interrupted you, sorry, the second paragraph there around interrelationship with hearings yet to be held. Of course, you recognise the issue for us. We have to issue recommendations on the IPI provisions that will embed certain matters, or likely to. So you're not saying in that comment that depending on hearings held next year, there will have to be consequential changes back to provisions being heard this year, are you? Or is it the other way around?
Guess I'm saying that, I mean, to take the noise chapter for an example, dependent on your recommendations and the decisions that are made for the noise chapter, there may need to be consequential amendments made to the subdivision chapter.
Right.
And I guess because noise and subdivision are in the same hearing stream, it's slightly easier.
Yeah.
But when you've got infrastructure occurring in hearing stream 9, I believe, dependent on kind of the objective policy level amendments that may or may not be made, there may need to be those consequential amendments to implement the directive through the subdivision chapter.
Right. So it will be there'll be limited opportunity next year to make any changes backwards to this year's hearings. Basically, well, no real opportunities unless you do a variation or something. Not even that really. So Wellington, you did the issue there.
I might just have to take that offline with
Right.
Husband Home Giles. That wasn't what I understood. We talked about this issue yesterday, and that wasn't what I understood we had reached, but I might have misunderstood. So I might
All right. When
talk
we
about
get
that
a
and come back
break.
to you. Yeah.
Yeah. Thank you. Okay. Sorry to interrupt.
Okay, so if we continue with earthworks, so I can provide a high-level overview of the approach of the ODP and how this compares to the PDP, if that is of benefit. So firstly, just in scene setting, the operative district plan had an earthworks chapter, and it has a single objective which seeks to provide for the use, development and protection of land and physical resources while avoiding, remedying and mitigating adverse effects of earthworks and associated structures on the environment. The ODP and PDP are very similar in their policies and rule framework as well as standards. Overall, it was found that the operative earthworks provisions, inclusive of their objectives and policies, have proved to be effective and subject to alignment with the national planning standards and some clarifications. The approach is very similar with the ODP and PDP. So the notified earthworks chapter includes 1 objective, 20 policies, 24 rules and 15 standards. The rules generally enable earthworks as permitted activities where they comply with standards, including, for example, cut and fill an area. Where activities would not comply with applicable standards, they become restricted discretionary activities. Earthworks for specific lower risk purposes or in particular zones are enabled via earthworks rules 1 through to R3, as well as earthworks 20, which is now renumbered as EW 17, which relates to the airport zone. Those lower risk earthworks are subject to compliance with specific standards, but not more general standards, which are via EWR4. So earthworks of a more general nature are enabled via Earthworks Rule 4 and attendance standards, and I refer to these as general earthworks. Earthworks in outstanding, significant or special areas are subject to specific rules which employ a mix of lower thresholds, such as consent may be triggered by smaller areas or disturbance, and or there may be a higher bar in terms of consent status, reflecting the sensitivity of the areas concerned and the relevant aims for those areas or overlays as expressed in the objectives in the parent chapters. In this sense, an earthworks activity could trigger multiple rules dependent on the number of district-wide matters or overlays in any given location. Then jump back to the tabled statement you have in front of you. I've just highlighted a couple of key recommendations, and again, I'm happy to speak through those. So I've identified 7 key recommendations. The first one being amendments to the rules for earthworks for the purpose of constructing and maintaining tracks in the general rural zone and the open space and recreation zones. So that was to tidy up and clarify rules R2 through to R5. The second amendment was to policies and rules for earthworks associated with natural hazard mitigation works. That is where they are permitted when undertaken by listed entities, and this was to align with the recommendations of Mr. Searle for the natural hazards section 42A report. I've recommended a new non-complying rule for earthworks within the ridgetop area of the Upper Steppings and Glenside West development area. This was a gap in the provisions that the PDP addressed the ridgelines and hilltops overlay, but not the ridgetop area. The fourth key recommendation is amendments to the rule framework for earthworks within significant natural areas, including a new non-complying activity where SNAs are within the coastal environment. This better reflects the directive of the parent chapter and gives effect to policy 11 of the NZCPS. Number 5 is amendments to standard 4 to increase the volume of cut fill material to 2,000 metres squared for the future urban zone. And this is an acknowledgement that earthworks in this zone will generally be at a greater volume in terms of transport. The 6th amendment is to the rules and standards for earthworks in the National Grid Yard and the gas transmission pipeline corridor. And this was in response to the submissions of Transpower and First Gas. And number 7, amendments to the rules and standards for earthworks within the airport zone, which is notified Rule 20 and Standard 14. And these amendments reflect changes proposed by Ms. O'Sullivan in her evidence. So then, to my mind, the only remaining point of contention is the activity status of earthworks within the National Grid Yard, where the relevant standards are not met.
Just your recommendations 3 and 4 highlight what I just was questioning before. That if we agree with you and lock in a new non-compliant rule for earthworks within the ridgetop areas, that's locked in. It can't be revisited next year when the whole landscapes topic is heard. And similarly with the SNA point there, that's yet to be heard. So we can't work backwards from there. If these are IPI provisions, I would note.
So I am 99% confident that all of the recommendations on that first point about consequential changes all relate to Schedule 1 provisions.
Okay.
But that matter with the ridgetop area, for example, it is identified in the PDP chapter for the development area. It's just an issue that it was left out of the planning maps. So
it wouldn't be a big issue.
That one in particular wouldn't be a big issue.
Thank you.
And to be fair, I don't think any of the submission points I'm speaking about would necessarily be big issues. It's more just that there would be a clarification of that objective and policy in those parent chapters, rather than a substantial change to that directive.
Okay, thank you. Any questions in the panel? I had one question, I may have more actually, but just in your section 42A report, and around paragraph 229, and this is about earthworks threshold. And it was a question rather than anything. Did you consider the 250 metre threshold in EWS1 as a reasonable limit? And there was a question around whether there was any sense in having a slightly larger volume of earthworks in some zones, and I'm thinking the centre zones, where you may get larger, deeper developments occurring. Was that sort of discussed or considered, setting that volume?
Yes, so this threshold across the different zones was considered whether a higher metric would be appropriate through discussions with consents and compliance staff as well as staff at the regional council. There was agreement that 250 metres squared was appropriate to manage those risk factors for erosion and sediment control, but it also relates to that kind of transport of cut and fill material as well, that thresholds in terms of the volume of earthworks across the different zones, depending on what zone you're in, doesn't change those risk factors because you're still transporting a significant amount of cut or fill through the city.
I've just got a follow-up question. How did you land on 250 square metres? What was the drivers for 250 square metres? Considering you've got the regional plans, when the regional plans kick in, it's what, 3,000 square metres? So 250 on a residential development side of any scale at all seems relatively low, because there's going to need to be some scraping of the surface at the very least to actually achieve what they want to achieve.
I believe it is a carryover from the operative district plan. And again, through discussions with council staff, they were comfortable with that figure, that it was an appropriate figure to be able to manage erosion and sediment control factors.
Was there any discussion about erosion and sediment control processes at all? It's in my experience with erosion and sediment control, it is getting a lot more straightforward, because a whole lot of people have done a whole lot of erosion sediment control plans saying this is the method that we're going to use to manage it, and particularly in relation to waterways, and particularly in relation to the size of sediment ponds that may or may not be required. So was there any thought about sort of simplifying the processes for information requirements in relation to earthworks consent where erosion and sediment control kicks in?
I think it's probably a fair point that the larger developers and applicants are very confident in their erosion and sediment control plans. There is the assessment criteria in standard S1 for which is the extent to which earthworks are designed and will be managed in accordance with the principles and methods in Greater Wellington's erosion and sediment control guide. So I guess
so
that
flicks it back to that dominant document, which
yes,
is the guidelines, but they're only guidelines.
Yes.
As well. So without, I don't think they've ever been through a Schedule 1 process, let alone anything else, those particular guidelines, but they seem to be best practice.
Yes, yeah, yeah. I would agree they're best practice.
Okay. Thank you. And the other one was, because it was mentioned before, to me, it was in relation to transportation of material, transport of. So you've added to 2,000 square metres a future urban zone, which relates to the Northern Suburb Institute Park, Glenside, Lincolnshire Farm sort of areas as well. City centres, mixed use, general industrial zones. And that's 2,000 cubic metres, which is quite a lot. But for the other zones, residential development, for example, it's down to 200 cubic meters, which is 20 truckloads in that order. Why the huge disparity in terms of volume calculations for that specific rule? Admittedly, it's only relating to transport of cut and fill material, but just was, my question was, why is there a big gap in between the two when you're essentially dealing with the same level of effect of transporting material, whether it's a residential zone or whether it's in a city centre?
I think, again, it comes down to that the 200 metres squared volume was what the consents and compliance team felt was the appropriate limit. And we did look at the number of truck movements that would involve. And so at paragraph 254 of my section 42A report,
Yep.
253 as well, I've noted that feedback from consents and compliance staff as well as regional council staff was that the 200 metres accounted for risk factors including narrow and steep roads throughout most of Wellington City, and that movements of heavy vehicles to and from sites can have adverse amenity effects through the generation of noise and vibration. And so the agreement was 200 metres squared, equating to approximately 27 movements, utilising a 7.5 cube.
I read all that, but I still couldn't work out why if a site is going to be developed, say for residential purposes, it's going to get developed and they're going to be doing various cuts and fills and they're going to be doing some benching and so forth. So it will need to be earthwork before it can develop to a greater or lesser extent, depending on the site involved. I just seen that there was a major disparity in between the 27 truck movements. It depends on how you calculate a truck movement, 7.5 to 10 cubic meters, depending on what it is. And those other zones where you're potentially looking at just get my maths right, 270 truck movements.
Yes. I think that.
Is it just that the consent people are just comfortable with what they've got? Is that what it is? And it seems to have been working.
Yes, I think that's a very fair comment to make, that the operative district plan has shown to be effective and we've stuck with the metrics. That 2,000 metres squared though for the future urban zone and those other zones listed is probably also just to acknowledge that there is expected and anticipated development occurring in those zones, probably at a larger scale than what you would expect on just a normal smaller residential lot. So I guess it's to acknowledge that those larger scale earthworks on a more full subdivision scale would equate to a larger volume of earthworks.
All right, thank you. I'll have some more.
Okay.
Around your paragraph about 333 on sites of significance to Māori. So it's really clarification. So the archaeological investigations don't trigger earthworks as such. They have all their own rules in that chapter. Is that correct?
Yes, that's correct.
It's not treated as earthworks. It's not.
No, it's captured under the definition or terminology of modifications.
And so those you're suggesting here 2 points that seem to me to be a good idea to clarify that. So no, we're looking, but you make a suggestion there that if we thought that it was necessary, then you could put standalone as an earthworks chapter. Do you think that's necessary? You satisfied with the just 2 points of clarification?
I think those 2 points of clarification would address the matter. I think it would make that kind of interrelationship between the historic heritage chapter and the earthworks chapter quite clear.
I was going to ask a question on that point too. So if we were to think about that, what would the nature of that policy look like without asking you to be verbatim about it, but roughly what would it say in your mind or could say?
I'd probably look to what the existing policy is and the existing SASM policy is, and I would, I guess, rephrase that to more directly relate to earthworks. But yeah, without looking into it, I can look it up if you'd like. See what it says.
The only other area I was going to just again clarification was in you're talking about EWP 12 at about section 47, paragraph 47. Oh, it's just above 473 actually. No, 475. And you're talking about P12. So you put those two clauses in together in one, but you have said you think that that distinction's clear, but if you think if we didn't, we could make them, we could separate them, which seemed to me to be more consistent with other approaches where they're separate. Is it?
Yes.
Is it?
Yes. So yeah,
Usually they're separated out because the second one always gets dropped below the first one, doesn't it? When they.
Yes.
Yeah.
Yeah. So exactly that. EWP 12 currently kind of has two directives in one policy.
Yes.
And I guess in a manner similar to its sister policies, CEP 6 and P7, those could be split out into two separate policies.
Yes, that would be consistent with that, wouldn't it?
Yes, there probably is a few other instances where that is the case as well, but no submitter has raised it in relation to those policies.
I think that would be helpful for clarity. Yeah. Thank you.
Yeah. Thank you. Going to earthworks within significant natural areas, and particularly looking at your recommendations for earthworks rule 7. Now you've got in there under the RDA compliance with the requirements of earthworks 7.1, which flicks it back to those things in the permitted activity, and that's all understood. And then you've got significant natural area does not include matters identified in policy 11 of the NZCPS. Now my reading of policy 11 of CPS is it's in two parts. Got to avoid effects on various different activities, which are really at the top of the hierarchy of things you actually want to, just avoid all adverse effects on. And then there's in section B, it's avoid significant adverse effects and avoid, remedy or mitigate other adverse effects on, and then it lists a whole lot of matters. So is there not a case to be made for making a distinction between those, the avoid policy in NZCPS policy 11 and the avoid significant adverse effects and avoid, remedy or mitigate other adverse effects process there? Because I don't think you actually sort of went into it in this particular section in your assessment about why that relief's posed.
So this probably, you're looking at policy 11 of the NZCPS, is that right? Yeah. So this probably relates back to that first point of my tabled statement that there is some matters where the earthworks chapter is seeking to implement the directive in the parent chapter.
Yep.
And objectives and policies in this case. The Eco R1 is the sister policy. So the distinction between EWR 7, 2 and is it 2 and 3 that you were looking at?
Yeah, so you've got RDA for things where policy 11 isn't triggered. And then you've got non-compliant for everything else.
Yes.
And I guess my question was that policy 11 is in two parts itself of the NZCPS, and whether or not you could, make a distinction about whether something is non-complying or restricted discretionary based upon the distinction between the two parts of policy 11.
I think it probably relates back to that. There's an eco policy 5, which sets the effects management hierarchy for Indigenous biodiversity.
Yeah,
And
unfortunately, we're not dealing with the eco chapter as well as an integrated whole, and I think this is one of the things which the chair's identified about what we're actually here to do. But is that a schedule 1?
It is, yes.
So it's probably less of an issue than anything under the ISPP.
Correct.
Okay.
But the intent of that differentiation between that restricted discretionary and non-complying rule is to replicate that sister rule in the eco chapter.
Okay. Because, just looking at this again, because under section 3, the non-complying, it's got the distinction about 11A in there.
Yes.
But it doesn't have any mention about what happens if it's an 11B ecosystem and what the status will be there. Is it that for RDA is identified policy 11A? That be what it's supposed to be?
That it more broadly would just refer to policy 11 of the NZCPS?
Yeah, so under the RDA, it's policy, does not include matters identified in policy 11. And then if you don't comply with that, you go to non-complying, and then it says where the significant natural area includes matters in policy 11A of the NZCPS. We're located within the coastal environment. I'm sure about where we're going here. So I guess the question is, what happens if it's an 11B ecosystem?
I think if it's an 11B situation, and again, this relates more broadly to the eco chapter, but in my view, it would, if it was an 11B matter, it wouldn't necessarily be identified within the PDP as an SNA. It would just more broadly be an area that has Indigenous vegetation.
Okay. So it maybe that EWR 7.2B gets amended to be 11A. Is that the solution?
Yes, which does the version you're looking at have red and green?
I'm looking at your 42A report.
Oh, okay. I'm looking at my.
Okay.
There's a supplementary one which might address this issue.
Right, which
does say 11A.
Okay, all right, that might have resolved itself.
Did you want to?
I have it electronically. So
Okay.
thank you.
Just a minor grammatical point. I think the reference to the chapter should be sites and areas of significance to Māori. It's just like where you've used it, like if you go to 339, page 68 of your 42A in the box, and also in your track changes or your proposed changes, it's just referenced as sites and areas of significance. But the chapters on my, yeah.
Yes,
So
agree.
just
Thank you for
typo,
that
just a
correction.
grammatical thing.
Just on that. For policy 13, tests there or the criteria, are they meant to be conjunctive or disjunctive? If you, do you have to pass all those criteria to be allowed? Because there's an and between the 4 and the 5, or an answer, I should say.
What?
13 EW,
What chapter, what page? you
earthworks,
on?
looking at your paragraph 400 in response to the council's environmental reference group, and I'm just trying to, maybe I should pick it up here.
400, did you say?
Yeah, paragraph 400.
Earthworks within riparian margins outside the coastal environment.
That's right. There's an and at the end between 3 and 4. I'm looking at the notified version, but not between 1 and 2 and 2 and 3. Are they all meant to be together, considered
Yes,
together?
they should all be.
Should all have an and after.
Yes, and just looking at the drafting in front of me as well, the same applies to EWP 1112, possibly others where it's missing that.
In the recommended amendments, Appendix A, there's no track changes, but it's quite a bit different. So I don't know. I don't know what's happened, but because the number 5 is not even on that one.
Sure, that's not worked out.
If you're looking.
Oh, that's because it's not. You're not confirming any change.
That's correct. Yeah. So that paragraph 400 shows what the submitter was seeking.
Yeah. So there's no change to that.
That's correct.
Getting recommended.
Confusing. Okay, and this may also be a silly question from me. Paragraph 438. I wasn't quite clear. You're recommending deleting B and C from the conditions to be a permitted activity in Rule 13. I wasn't quite sure why you wanted to delete.
So
Clarify that.
absolutely, that relates to EW 2, 3, 4, and 5. So those rules and what is in EWR 13 will address the same matter in quite a repetitive way. So EWR 13 so that related to the maintenance or construction of farm tracks required for permitted rural activities and referred to EWS 8 when that is exactly what EWR 2 achieves as well as a permitted activity.
Okay.
So it's just removing that duplication that was there. No change to the substance, just simplifying and clarifying that rule framework.
Thank you.
Any further questions on earthworks? Thanks. That's all. We might as well box on with subdivision if that's all right, unless there's any contribution to the earthworks.
No, I had nothing on earthworks, so.
So we can turn back to your tabled comments. Would like to read out statement.
So before I continue with my tabled statement, would it be helpful if I just again ran through the ODP and PDP, how they all work?
Yep.
Cool. So in the ODP, subdivision objectives, policies and rules are embedded in each of the chapters relating to particular zones and in a citywide chapters for matters such as heritage, contaminated land and utilities. The subdivision policy in the ODP for most zones was headed by a commonly worded objective, which was to ensure that to ensure that the adverse effects of new subdivisions are avoided, remedied or mitigated. And again, there was a commonly worded policy, which was for sound design, development and appropriate servicing. The key differences between the ODP and the PDP are that the approach for general management of subdivision is not substantively different in scope or substance, although it does offer a simplified policy direction and regulatory approach for clarity and effective administration. The PDP takes a more enabling approach to urban subdivision, given that there is strong imperative to adopt such an approach under the NPSUD in terms of increased supply and choice for housing. There is also the introduction of new controls to protect nationally and regionally significant values, which represent a higher degree of regulatory stringency for affected persons and communities. And existing subdivision controls under the ODP for domain-specific matters such as heritage are generally retained under the PDP, albeit with refinements to align with the national planning standards and integrate with the PDP as a whole. So in the notified version of the subdivision chapter, there are 2 objectives, 26 policies, 31 rules and 7 standards. In terms of how the subdivision chapter works, with the exception of subdivision rule 1, the general subdivision objectives, policies and rules apply to all subdivision proposals, including those that affect land subject to other planning map notations, areas or overlays. In this sense, a subdivision application could trigger multiple rules depending on the number of overlays or district-wide matters relevant to the site. Jumping back to my tabled statement. So similar as I did for earthworks, I've identified 8 key recommended amendments. The first of those is deletion of all references to consent notices and legal instruments and policies and rules, as there are legal mechanisms outside of the district plan available for these. The second relates to the airport, which is the introduction of a new policy for subdivision within the inner air noise overlay, where the permitted density of noise sensitive activities will avoid reverse sensitivity effects on Wellington International Airport. This policy directive supports the notified discretionary activity rule, which I have recommended adding a notification clause that Wellington International Airport be considered an affected person. The third is in relation to heritage. I have recommended amendments to the subdivision heritage policies to add that regard is to be had to the advice from a suitably qualified heritage professional, as well as Heritage New Zealand. These amendments were in response to the submission of Wellington heritage professionals and also align with the historic heritage parent chapter provisions. Number 4 is I've recommended amendments to the rule framework for subdivision within SNAs, including a new non-complying activity where SNAs are within the coastal environment to better reflect the directive of the parent chapter and give effect to policy 11 of the NZCPS in a manner similar as I did to earthworks. Number 5, amendments to the natural environment value subdivision rules for SNAs and ONFLs, that a building platform as well as areas for access to that building platform be identified for each undeveloped allotment. Number 6 is clarification to the policy and rule framework, including a new restricted discretionary rule, subdivision of land within the Ridgeline and Hilltops overlay, and the Ridgetop area of the Upper Steppings and Glenside West development area. Again, similar to earthworks, this was a gap in the provisions that there was no subdivision rule for ridgelines and hilltops or the ridgetop area. Number 7 relates to infrastructure, which I've recommended deletion of sub R27. That rule addressed subdivision in the now redundant National Grid subdivision buffer. I've also recommended amendments to the National Grid and gas transmission pipeline corridor rules, of which both Transpower and First Gas support the relevant recommendations and raise no outstanding matters. And finally, number 8, I've recommended deleting the minimum allotment size for centres and industrial zones to provide for flexibility and innovation and choice. I've also identified what I consider to be the 4 remaining issues in contention, which I can read through as well. The first is whether there should be a restricted discretionary rule for subdivision within the buffer areas of the road and rail corridor, as is raised in the evidence of Kiwi Rail and Waka Kotahi. The second is the appropriateness of a new objective or amending sub 01 when the national planning standards establish the structure of the PDP, and that when the plan is to be read as a whole, there are outcomes that address the matters raised by submitters. The third is the appropriateness of a minimum shape factor, which is sought by Kāinga Ora. And finally, the subdivision 3 water standards, which may have been in part addressed or responded to by Ms. Cook this morning.
Thank you. Any questions?
Just because I've got your supplementary evidence in front of me, I'm just asking a question for that, but I think it comes up in the main one as well. But it's about this size and shape issue. Is it a design guide issue? Does that come up under that? I get that it's a requirement, but also can that not be dealt with how that where you have a building?
It could be. I would have to go back and have a read through of the subdivision design guide.
I think they're being I don't know.
That is being addressed in
Here, but isn't it
hearing stream 6.
Yeah, I just wondered whether you thought that was because you've recommended that it not be.
Correct.
In fact, it's one of your last issues of contention, isn't it?
Yes.
That's I just wonder if that's where is it better addressed anyway.
Yes, that's something that I could go back and look at, but also probably in hearing stream 6. There is the one point in relation to the subdivision design guide that's probably worth raising, that in as far as I've been able to find, there's only one reference to the subdivision design guide in the whole subdivision chapter. So as part of that review process for the design guides, it would probably be beneficial to kind of go back and check through those references to the subdivision design guide to make sure.
Where is the trigger for it? I didn't see it.
I believe it's in the boundary adjustment rule.
Boundary adjustment. Right. Well, that's easy to find. What rule would that be?
So it's in the only reference as in sub R3 3 as a matter of discretion.
Let's find it.
3.3 in the second matter of discretion.
Subdivision appendix A. So what rule was it? Sorry.
R3.
R3.
It's on the bottom of page 15, the second matter of discretion.
Oh, yeah. Yeah, there should be some other triggers for it, shouldn't there?
Agree,
I
yes.
would have thought. Oh, well, but leave that one. That's part of that review anyway, isn't it? I did go to someone else if there's something while I'm still going.
If I can just note one other amendment in sub R11. There's an issue where Sub R11.3, the non-complying rule should say the subdivision is located within the coastal environment, where it currently reads located outside of the coastal environment.
Non-complying activity,
Yes.
that should be what?
So
Outside?
it should be located within the
Oh,
coastal
within, not
environment.
outside.
Yeah.
Sorry, has it been picked up by your supplementary? Or?
No, it's not noted, and I've just picked it up now.
Oh,
So.
I think we may ask for that to be.
I'll address it. Yeah, absolutely. I'll address it in my writer reply.
Was another sort of design guide kind of issue, which was around this your use of the word local context as opposed to underlying zoning, which I agree there's merit in doing that, but I think that's also something the design guide would cover. So I was saying it's sort of local context is a consistent term to use because it links with that,
yes,
as opposed to it being zoning necessarily.
Yeah.
Let's pass on to somebody else.
Okay, while the others are thinking about the questions, I've just acknowledged what you said in the supplementary around paragraph 35, 36 around policy language and policy. I don't know, but if you're aware, but my minute on the wrap up here is this issue itself. So we're just seeking a little bit of advice about what the policy language side word used, and if there's any situations where sort of variations from that language are appropriate to apply. Yes, we've picked that point up. Questions? Just my question around the shape factor, because I'm old school planner and just brought up shape factors. And I know the MPS has a direction over this, but I suppose it relates to Commissioner Black's comment around using a design guide around this, because I mean the point of a shape factor was to avoid ultra skinny lots or lots you couldn't do a lot with practically. So I think just making the point there, asking a question there. But I am aware of the direction under the MPS around. So those things are not enabling, shall we say?
Just on that last point, I think the shape factor is all about trying to avoid ransom strips or segregation strips as well. As being unclear, an undesirable outcome. But certainly a lot of plans do have shape factors in there. And proof that you can do something in accordance with the zone on the lot. I don't have any. Well, I've only got one specific question, and you would have heard of the discussion on Three Waters this morning. And in relation to para 301 of your 42A report, we're talking about you draw us to the attention of THWP5 about model peak flows and volumes from an undeveloped state. So in relation to some of the Three Waters discussions that we had this morning, perhaps that particular provision needs to be looked at in that light as well in terms of a response. Okay. No, a difficult subject, and you seem to have covered it very, very well.
Thank you. I appreciate that.
So looks like we're going really quickly today. So Wellington, that matter that you were going to discuss over afternoon tea. How best?
Well, I can
Just have a
come back
discussion.
first thing in the morning, or
Yeah.
if you want to have a break and then come back in 15 minutes.
We do that? Yeah.
So you can-
Yeah.
I'm
Oh,
coming
you
back
are
in the morning
coming
anyway, but so it's really up to you.
Or maybe we'll get it addressed first thing in the morning.
Oh, well, sure, that's all, but you can tell me.
Okay, we'll adjourn the hearing for the day and resume at 9 o'clock tomorrow morning. Thank you.
Thanks.
Thanks, Jeff. He has no idea what to do. Oh, here's Jazz.